Testing 1 2 3. Testing 1 2 3.
Good morning, everyone. We're here today for oral arguments. We're going to begin with Appeal 24-2000, United States versus Deontay Tyler. And Mr. Spengler, we'll begin with you.
May I proceed?
Yes.
Thank you, Your Honors, and may it please the Court. My name is John Spengler. Today I'll be arguing on behalf of the appellant, Deontay Tyler, as supervised by Professor Bob Palmer of the Notre Dame Law School. Your Honors, as stated in appellant's reply brief, the only issue still before the Court today is that of procedural error, and so only de novo review applies. The District Court committed two distinct species of procedural error at Mr. Tyler's resentencing hearing, each independently requiring a remand. First, the District Court failed to respond to Mr. Tyler's principal arguments in mitigation as required by this Court's decision in United States v. Miranda. Second, even if Mr. Tyler had offered no principal arguments in mitigation, the District Court independently failed to explain its choice of sentence as required by 18 U.S.C. 3553C1, given both the anomalous result with respect to Mr. Tyler's co-defendant, Dalvin Jackson, and with respect to the guidelines themselves.
Mr. Spengler, I thought a good deal of Mr. Tyler's position seemed to be that he ought to get a lower sentence than Jackson, right?
That's correct, Your Honor.
And he did in the end, correct?
In the end, Your Honor, yes, that would typically be analyzed under substantive error. Here, the District Court's...
And you've withdrawn that argument.
That's correct, Your Honor.
So what's the problem?
Well, at the District Court's resentencing hearing, the explanation offered, both with respect to the mandatory statutory factors and particularly as applied to Mr. Tyler's co-defendant, Dalvin Jackson, was insufficient. That's the case for a couple reasons. There was two specific principal arguments in mitigation raised by Mr. Tyler. That was that he deserved a lower sentence due to the need to avoid unwarranted sentencing disparities under A6. That argument was made specifically with respect to Dalvin Jackson. And then there was also a second principal argument in mitigation made with respect to the 7-level enhancement imposed on him as a result of the discharge of a weapon during the commission of the robbery. That 7-level enhancement was imposed despite the fact that Mr. Tyler did not discharge the weapon.
Right. That fact, however, had been discussed at some length in the original sentencing hearing, and none of it had changed for the second sentencing hearing, right?
That's correct, Your Honor.
So how much does the district judge, frankly, I read the judge's explanation. I thought this is a very thoughtful, thorough, individualized sentencing explanation.
That's correct, Your Honor. If the standard for finding a procedural error was the length of the discussion offered by the district court, then there wouldn't be an issue here. However, Miranda is very clear that the district court has to conduct a renewed individualized analysis with respect to the principal arguments actually raised by Mr. Tyler at his sentencing hearing. Again, there was an
Go ahead.
There was an A6 and an A1 argument made. Here, the district court addressed the A6 argument at a couple particular places. The second, that's the appendix at pages 29 to 30, there the district court addressed the prior reasoning that it offered at Mr. Tyler's first sentencing hearing. The government here argues that under the United States Supreme Court's decision in United States v. Chavez Mesa, that any explanation offered at a prior sentencing hearing can justify its procedural burden at Mr. Tyler's current sentencing hearing. However, Chavez Mesa on its own terms applies to a sentence modification after a change in the applicable sentencing guidelines. Here, the district court was relatively clear in the grant of its 2255 motion that it was conducting a plenary resentencing hearing with respect to Mr. Tyler. And so unless the district court made clear or otherwise stated that it was incorporating the reasoning from its prior sentencing hearing, it was required under this court's precedent in Miranda to conduct a renewed individualized analysis with respect to Mr. Tyler's principal arguments in mitigation.
One of our general principles about sentencing is that the judge need not belabor the obvious.
Correct.
You find that throughout our opinions, and
Yes, Your Honor.
I guess I'm trying to understand what was not obvious about the judge's rationale here.
Well, Your Honor, importantly...
You would agree that Mr. Tyler could have been sentenced to 330 months again, right?
Your Honor, we're not pressing the substantive reasonability of the sentence here, and so we're not making a claim as to what the proper range of sentence would be anymore. The discussion today is purely limited to the rationale offered by the district court.
And there was no change in the defendant's conduct, right?
Other than that, they'd be considered post-conviction, correct?
And that was a mixed bag for him.
According to
Correct.
the district court, that's correct, yes.
Right. You disagree with that?
No, we don't contest
Okay.
this.
So, and I understood Mr. Tyler's comments in the transcript indicate, in essence, since my 924C 10-year mandatory minimum got knocked out, I'm entitled to a 10-year shorter sentence, which I think we all agree is legally incorrect.
That's correct, Your Honor. Yes, we're not pursuing that appeal.
So I guess I'm still struggling. What more did the district judge need to do here?
Again, Your Honor, had this been a case like Chavez Mesa, where it was a simple sentence modification following a change in the guidelines, they could have relied on a prior explanation. But as the district court made clear, this is footnote 2 in its opinion related to the grant of Mr. Tyler's 2255 motion, it was conducting a plenary resentencing hearing.
Does that mean she needs to repeat everything?
No, Your Honor. However, the district court never said that it was incorporating or adopting the reasoning that it raised at its first sentencing hearing.
Well,
It
she
was
came pretty
relatively
close, but
At pages 29 and 30 of the appendix, Your Honor, the district court made clear that when it offered its reasoning under A6, it was doing so only to correct Mr. Tyler's misunderstanding with respect to his first sentencing hearing. The district court said that part of what you remember of what occurred at your first sentencing hearing is correct. Some of it is different. And so all that was a correction of Mr.
But
Tyler's.
I thought she started early on along the lines that Judge Hamilton is suggesting by referring to everything that has not changed. And then what really stood out in the transcript to me is at no point in time did the district court lose track of the fact that Dalvin Jackson was a co-defendant. It wasn't like she forgot that. She doesn't know who Dalvin Jackson is. There's nothing like that. And she references in the resentencing proceeding that yes, Mr. Tyler is less culpable or slightly less culpable because he's not the one that fired the shot inside the house, but he did engage in very, very concerning behavior, both inside the house and in fleeing from the police department.
Correct.
And so I don't see how when you talk about this in terms of avoiding an unwanted disparity, especially with Mr. Jackson, I don't think the district court ever lost track of that.
Not necessarily, Your Honor. However, it is important that the district court never did actually mention Dalvin Jackson specifically, despite the fact that the sentence rendered against Dalvin Jackson.
She talked about Tyler not firing the shot. Who else would she have had in mind?
Correct, Your Honor. That was Dalvin Jackson. However, whenever the district court did specifically address the merits of an A6 claim, it did so only with respect to Liddell Tyler. And here, the other argument pressed under the mandatory statutory factors was under 3553A1. And there, the district court, the only time the district court mentioned the gun head-on directly, as I read it, is page 28 of the appendix. There, the district court mentioned that the gun was being passed around, which is why Mr. Tyler was still on the hook for it. However, the best reading of that is that it simply refers to the reason that Mr. Tyler is still on the hook for the 922G1 conviction, as opposed to the 7-level enhancement due to the discharge of the firearm. That's because the discharge of the firearm was required for the imposition of the enhancement. And again, even if that does refer to the 7-level enhancement imposed on Mr. Tyler, that would just be describing the factual circumstances necessary to impose the enhancement, as opposed to a justification for treating Mr. Tyler the same with respect to the guidelines as they did at the first sentencing hearing.
Would you like to reserve the remainder of your time?
Yes, Your Honor. Thank
Very
you.
good. Thank you, Mr. Spengler. Mr. Keenstra will now move to you for argument on behalf of the government.
May it please the court. Good morning, Your Honors. Jeff Kinstra on behalf of the United States. The defendant waived his procedural objection in the district court, and he's withdrawn his substantive objection on appeal. And in any event, as Your Honors have recognized, the district court more than adequately explained its sentence, addressed the defendant's arguments of mitigation, and applied the 3553A factors to the individualized circumstances of this case. Now, at the outset, the defendant waived his objection as to the arguments of mitigation by expressly telling the district court at the hearing that the court had, in fact, addressed all of those arguments. The district court asked a pointed question about that. Counsel responded in the affirmative. Yes, Your Honor, the court has addressed the arguments. Counsel clearly understood that as an opportunity to seek clarification because he did as to the prior guidelines ruling. The court said, I'm happy to provide that clarification. She did, and then she asked if the explanation was sufficient. Defense counsel confirmed that it was, and so that's a waiver.
So the defense argues, Mr. Keenstra, that in essence we shouldn't enforce the Garcia-Segura waiver here because, in essence, the discussion continued, particularly between the defendant himself and Judge Darrow.
Sure.
Your thoughts?
So I think that fails for two reasons. The first is that the district court didn't accept further substantive argument from the represented party at that point in the hearing. The court corrected the defendant when he said that he had received an above guideline sentence. She said no, it was within the guidelines. Beyond that, the court redirected the defendant back to her question, which she said was a yes or no question. Do you understand that you have 14 days to appeal the sentence? When the defendant continued arguing after that point, the judge referred her question to defense counsel and said, are these matters that have already been raised? Counsel said yes. And that was consistent with her approach throughout the hearing, which was to not accept substantive argument from the represented party. And then my second point would be that the matters the defendant was raising at that point have nothing to do with arguments he's raising on appeal.
Right.
He was arguing about the sentencing enhancements, which he's not raising on appeal. And so that wouldn't avoid waiver as to the arguments in mitigation, which is
What I'm wondering about, I'll confess to having been present at the creation of the Garcia-Segura question, in essence, to help deal with all of those Cunningham failure to address appeals that we had a number of years ago. And generally the process, I think, has worked pretty well. I wonder, though, so that those matters are addressed on the spot rather than a year later or a year and a half later when there's a remand. But I'm wondering whether it might be useful in this case, and would appreciate your thoughts as somebody who's in these courts all the time, to maybe suggest to district judges that in this kind of a situation where you ask the question, have I sufficiently addressed your arguments in mitigation, and the argument or the hearing then continues substantively beyond that, maybe to circle back to that question again.
I think depending on the context, that could be useful. If there had been further substantive discussion at that point and the defense counsel was raising additional issues, maybe it would be appropriate for the district court to either address them or confirm that the defendant isn't requesting any further explanation. But here it was all done through the defendant, a represented party who the district court wasn't accepting further argument from. If this had been an issue of defense counsel standing up and saying, actually, Your Honor, there was this other argument I meant to address, or I meant to raise, I'm raising this new argument now, and the court responds to it, perhaps in that circumstance it would be appropriate for the court to conclude its discussion saying, like, does that address the concern that you've now raised? But I think that's very different from the circumstances we have here. As to the adequacy of the court's explanation, this was a really thorough and considered discussion under the circumstances of this case in particular. The court went through all of the relevant 3553A factors, and during the course of that discussion, it directly addressed, and in fact agreed with the defendant's argument in mitigation, that he was less culpable because he wasn't the one that fired the firearm. On page 30, the district court said, you are somewhat less culpable than your co-defendants because we know one of them fired the firearm. The court said that was notable to distinguish you from your co-defendants. As to the defendant's argument that this was all just talking about what happened before and not part of the court's explanation for this sentence, at the top of page 31, the court said, what I said before is true. So it's adopting all that discussion. Again, on page 35, the court said, nothing has changed about the seriousness of the offense conduct and the need to avoid unwarranted sentencing disparities. So the court directly addressed this argument in mitigation, that the defendant wasn't the one who fired it. She agreed with that. She said that was mitigating relative to the co-defendants. And so ultimately, really, the defendant's complaint is weight. The defendant's argument is that the court should have weighed that more heavily and reduced the sentence even farther below his co-defendant. But that's a substantive objection, not a procedural one. The court addressed the principal arguments in mitigation. How the court weighs it is not a procedural issue. Regardless, the defendant had not received the same sentence as his co-defendant, either then or now. The co-defendant received a sentence of 240 months on the two counts at issue, the attempted robbery and the firearm possession. But it wasn't 240 months alone. It was consecutive to another 120 months. So the court exercised its discretion on those counts to impose enough time to produce a total sentence of 360 months. For this defendant, it was a total sentence of 240 months. And that's abundantly obvious now that the co-defendant has been resentenced and received a 24-year sentence as compared to this defendant's 20-year sentence. Unless your honors have any further questions, we'd ask this court to affirm.
Thank you, Mr. Keenstra.
Thank you.
Mr. Spengler, we'll go back to you for rebuttal and give you 2 minutes.
Thank you, Your Honor. 2 brief points on rebuttal. First, on the waiver question, it cannot both be the case that a Garcia-Segura waiver controls on the facts of this sentencing hearing and that Garcia-Segura is consistent with this court's background waiver jurisprudence. Cases like United States v. Vasquez and United States v. Barnes are relatively clear that this court must look to the entire relevant record and construe it liberally in favor of the defendant and be cautious in finding an affirmative waiver of an argument by the defendant. If Garcia-Segura controls simply by having an affirmative response to a Garcia-Segura inquiry, that would be not looking to the remainder of the record, especially after the Garcia-Segura inquiry, where Mr. Tyler specifically sought to, quote, preserve his sentencing memorandum, and where that sentencing memorandum contains an express argument related to Section 3553A2. Turning to the point about whether or not the district court actually agreed with Mr. Tyler's principal arguments in mitigation, the points in the record cited by the government primarily deal with the factual circumstances of the crime, where the district court was stating that nothing had changed and that everything remained true. That referred to the circumstances of the conduct of Mr. Tyler. It did not refer to the actual weighing of the statutory factors. As stated previously, any explanation offered at a prior sentencing hearing, unless actually accommodated into the record, is insufficient to meet the district court's duty under Section 3553C1. And so with that, we would respectfully request that this court vacate the amended judgment of sentencing entered against Mr. Tyler and remand for the resentencing hearing. Thank you, Your Honor.
Thank you very much, Mr. Spengler. Thank you, Mr. Palmer. This case has been accepted by you as a court-appointed counsel. We want to thank you for all your time, effort, and energy on behalf of your client. Thank you as well, Mr. Keenstra. The case will be taken under advisement. We are going to move now to Appeal 23-2690, Grant Gambiani versus Brittany Green. We're going to commence with oral argument on behalf of the appellant, Mr. Kern, from you.
Good morning.
Good morning.
May it please the court, my name is Nicholas Curran, and I represent the appellant Grant Gambiani. Mr. Gambiani respectfully requests that this court reverse the district court decision to deny Mr. Gambiani's petition for writ of habeas corpus. There are 2 primary issues raised in the briefs that I would like to address this morning before the court, and both of those issues relate to the courtroom closure issue that is raised in this appeal. The first issue is whether the courtroom closure during Mr. Gambiani's trial was a partial closure or a complete closure under the Sixth Amendment. The second issue is whether the record supports the state appellate court's finding that Mr. Gambiani waived his fundamental right to a public trial based on his attorney's purported agreement to the closure. As to the first issue, the Sixth Amendment is clear. It provides that in all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial. The plain and ordinary meaning of the amendment guarantees a criminal defendant's right to a trial that is accessible by the public. The text of the amendment does not qualify or limit that right. Mr. Gambiani's trial was not open to the public during the minor victim's testimony.
Well, 2 individuals were asked to leave.
That is correct, Your Honor.
The father remained. The media question was checked upon. It sounded as if it was, I don't want to call it an afterthought, but an issue that arose during the course of the trial proceedings, which was then handled by the trial court. How does that raise to the level of a constitutional violation?
Well, Your Honor, for several reasons. First and foremost, we have Supreme Court precedent that addresses a situation exactly like this. So in Globe newspaper, a case cited in our brief, the Supreme Court addressed a very similar situation in which a Massachusetts statute provided that it was mandatory for a trial court to close the courtroom during a minor victim's testimony in sex offense cases, with the exception of individuals who had a direct interest in the case.
And I understand the attempted First Amendment connection there. Here, the media just didn't sound like they were interested in the case. Isn't that a fair conclusion?
Well, I think that we know that the media did not attend the trial. And, Your Honor, it is correct that in Globe newspaper, the Supreme Court was addressing a public trial claim in the context of the First Amendment because it was the press that was challenging the statute. But the rationale of Globe newspaper was extended to criminal prosecutions in Waller. In Waller, the Supreme Court held that the protections provided to a criminal defendant under the Sixth Amendment are at least as extensive as those extended to the press and public by virtue of the First Amendment.
Mr. Curran, given that we're here on post-conviction relief under 2254, is it your position that the state appellate court's decision is contrary to any Supreme Court precedent?
Yes, Your Honor.
Okay. And which, contrary to, is an awfully difficult standard to meet because you got to show factual identity.
Correct, Your Honor.
Which case?
Or an unreasonable application of clearly established
Right, I'm focused
federal
on
law.
the first prong, contrary to. So what case is the Illinois appellate court's decision from the U.S. Supreme Court contrary to?
So Waller versus Georgia is directly on point. So the
There's
first
one
question-
rather important difference, which was that the defendant in Waller objected, right?
That's correct, Your Honor.
Is it your position that Waller requires the trial court to undertake and make those four-factor findings in the absence of an objection?
So, Your Honor, what we have here are two distinct issues. The state appellate court could have reasonably found, based on state law, that Mr. Gambiani forfeited his right to raise his public trial claim on appeal. It did not do that. Instead, it held that he affirmatively waived his right to a public trial, which goes to the unreasonable determination of the facts portion of the argument which we raise in the brief.
Could you answer the question that I asked, which is whether you think Waller requires a trial judge to make those findings in the absence of an objection?
I think that they do, Your Honor.
How do you get that out of the opinion?
Okay, so it's I guess I should clarify my answer. It's not Waller alone. It's every other case, and the cases are legion from the Supreme Court, that every reasonable presumption is to be indulged against the waiver of fundamental constitutional rights. And the right to a public trial is a fundamental constitutional right. The state does not dispute that to be true.
As a general statement, that's true. But you seem to be making an argument here for a very specific application, saying you need to have on-the-record findings consistent with the Waller factors, right?
Correct.
And I'm looking for a Supreme Court case that requires those findings in the absence of an objection.
Your Honor, it's the combination of multiple cases that address whether or not or under what circumstances a court may find that a defendant has waived a fundamental constitutional
So by
right.
definition, it can't possibly be contrary to, on the first prong of 2254 D1, because you don't have factual identity. I mean, the Supreme Court has been as clear as day in Williams v. Taylor and in Harrington versus Richter, not on the unreasonable application of prong, on the contrary to, you need factual identity.
Your Honor, I would agree that this is not a case where you have exact factual
So you
identity.
can't. So there's no way you can prevail into the contrary to prong.
It's an
You
unreason-
got it right, but those are two different statutory standards in 2254 D1. In other words, the state court decision denying relief, you can grant post-conviction relief if the state court decision is contrary to or reflects an unreasonable application. There are two different standards.
I agree with that, Your Honor.
Okay, so
And the argument is not that the Supreme Court has addressed this exact factual scenario.
So you're not making an argument that there's anything contrary to Supreme Court precedent. You're making an argument that there's an unreasonable application of Waller, Presley, et cetera.
Correct. That is correct, Your Honor.
Supreme Court has said that we can't extend a rationale before it can apply to the facts at hand. So by definition, the rationale would not have been clearly established under federal law, correct?
Well, I disagree with that. I mean, again, there are different pathways to get to habeas relief. One is if you have a Supreme Court case that's exactly on point, exact same factual circumstances. I would concede that we don't have that here because of the lack of an objection. But you also get to habeas relief if you can show that the district court's decision constitutes an unreasonable application of clearly established federal law as articulated by the United States Supreme Court. Mm-hmm. That's our argument here. And it
Mr. Curran, would you agree that the trial judge complied with the Illinois statute?
Well, the state court held that he nominally complied with the closure statute under Illinois law, although
Well, they
it did
didn't
have,
like having the prosecutor carry it out. I understand that.
correct.
But the substantive decision to close was consistent with the Illinois statute, correct?
Correct.
Okay. Okay. I guess I'm struggling here with the position of the trial judge, who's got a statute telling him do this, and nobody objecting to doing that, and you're saying it's a constitutional violation for him to just move forward without going forward and making a bunch of extra findings.
I understand what your Honor is getting at. Part of the problem here is the way that the prosecutor framed the issue. So as the court will recall, there were two trials in this case. The first trial happened. We get to the second trial. We have new counsel on behalf of Mr. Gambiani. The prosecutor, without re-noticing the motion to close the courtroom during the victim's testimony, said, Your Honor, the victim is still underage, and under the Illinois courtroom closure statute, the courtroom should be closed. That actually is not what the courtroom closure statute states. The statute states that it is the court's discretion to close the courtroom if it feels that in the interests of justice or in the best interest of the minor, the courtroom should be closed. So the prosecutor here sort of propelled this issue in the way that it proceeded. Defense counsel was taken aback and probably because he didn't know this was going to be an issue, and clarified with the court, well, if Your Honor is inclined to grant this, my client would ask that his father be allowed to remain. What the state appellate court ultimately held was that constituted an agreement for the courtroom to be closed. And that's just not true. That's
Acquiescence was the word, right?
correct. And again, that violates the basic Supreme Court precedent that every reasonable presumption is to be indulged against the waiver of fundamental constitutional rights.
Well, what do we expect defense counsel to do? I mean, if he's got a problem, he knows how to object. He's not the proverbial potted plant, right?
Correct. And this is a case where the state's appellate court could have said, well, Mr. Gambiani, through the failure of his trial attorney to object, has forfeited this issue on appeal. But that's not what it held. If it had so held, this would have been raised as an ineffective assistance claim based on his attorney's failure to object to closure of the courtroom during the most important
But the difficulty for me with what you're saying is that it's as if we are in this courtroom conducting direct review of the Illinois Court of Appeals decision. We're not. We're in 2254. And so in answering Judge Hamilton's questions, I think you have to be able to demonstrate that the Illinois Court of Appeals decision, to the contrary of what, or, at odds with what you're arguing, is beyond fair-minded disagreement. It's baseless. It's off the reservation. It's completely wrong.
Your Honor.
That's the standard the U.S. Supreme Court has handed down.
Right. So, Your Honor, the Sixth Amendment says every criminal defendant has a right to a public trial.
You have to focus on why the Illinois Court of Appeals decision is beyond fair-minded disagreement.
Correct. And as to there's two components to this. One is the waiver issue, which is addressed again by many U.S. Supreme Court cases that talk about what's required to waive fundamental rights. Then you have the courtroom closure issue. And here, the court ordered the courtroom doors to be barred without giving any thought to whether or not the government had articulated.
So what U.S. Supreme Court, you have to come back to 2254. No matter whether you like it or not, this is a 2254 appeal.
Understood.
So what U.S. Supreme Court decision or decisions render it beyond fair-minded disagreement that limited closure of a courtroom during a criminal trial where a minor is testifying violates a Sixth Amendment right to a public trial?
Your Honor, I disagree that this was a limited closure. This was a complete.
It was, as a matter of fact,
I
because of what Judge Brennan observed.
I disagree with that because in Globe newspaper,
I thought there were people left in the courtroom.
the U.S. Supreme Court has never.
Hold on. Let's talk about the facts. Was the courtroom 100% emptied?
Courtroom personnel, the parties, Mr. Gambiani, and his father. His father was the only person who was allowed to remain in the court.
So it wasn't a complete closure, as a matter of fact.
The Supreme Court has rejected the notion of a partial closure under those circumstances. In Globe newspaper, individuals with a direct interest in the case were allowed to remain in the courtroom. The Supreme Court did not say, oh, well, because individuals with a direct interest in the case are allowed to remain in the courtroom, that means that the courtroom is not closed
So the exclusion
to
of the media in Globe newspapers was problematic. And here the Illinois statute allows the media to be present.
It does, but the media was not present. So
That's their choice, though.
It is, most certainly. But
It wasn't, in fact, the trial court made an effort to determine whether there was any media present, and there wasn't.
That's correct, Your Honor. But the idea here is that the media can act as a proxy for the public, right? That would be the reason why.
So your argument's a lot better if the local newspaper reporter is knocking on the courtroom door saying, hey, we want to cover this. What do you mean the courtroom door is locked?
I guess I don't follow that, Your Honor, because the Sixth Amendment does not guarantee a criminal defendant the right to have media present at his trial. His right is to a public trial, and that's something that the U.S. Supreme Court has not wavered from. So there's conflating of some different concepts here. I think that, and I do see that I'm close to running out of all my time.
We'll give you a bit of rebuttal time.
I had hoped to reserve some time for rebuttal, and I understand Your Honor's concern. Our argument is that if you look at the two different strands of case law, you have the Waller strand, which addresses what's required before a courtroom may be closed, and then the other line of cases that talk about, well, what's required to waive a fundamental right. It's those two strands that the state appellate court here unreasonably applied in denying the public trial claim. I appreciate the court's time.
Thank you, Mr. Kern. We will give you a bit of rebuttal time. Ms. O'Connell will now move to you for argument on behalf of the appellee.
May it please the court, I'm Assistant Attorney General Erin O'Connell on behalf of the respondent warden. I think based on opposing counsel's argument this morning, he's failed to identify a Supreme Court case that's on point, that clearly establishes a principle that the state court in this case was either violating in a contrary to way or unreasonably applying. Two cases have been offered, Waller and Globe newspaper, and both of those are distinguishable. Globe newspaper was a closure to the courtroom that included the media. It was actually a media case. The media objected and they were nevertheless excluded. That obviously didn't occur here. We had no media excluded from the courtroom. And Waller is distinguishable on two bases. The first is that there was an objection in Waller, and the second is that Waller was a total closure of the courtroom.
Would we be improperly extending a Supreme Court holding or rationale if we held the trial court should have gone through the Waller criteria?
I believe so. I think Waller is premised on the presence of an objection. And if a defendant has objected to a closure, then the trial court has to make certain findings and go through certain alternatives before the courtroom can be closed completely. So it would require an extension on that point. And then it would also require an extension because we don't have a total closure here. So that's another basis on which Waller is just fatally distinguishable for purposes of 2254. We did have the father present in the courtroom here. The only people that were excluded were determined to have no direct interest in the case, and we had no media that was trying to access the courtroom. So those factors just require this court to deny habeas relief under the stringent standard of 2254D.
Gambiani has identified some inconsistencies in his attorney's presentation. How do you respond to those?
On the,
What the attorney that was present at the trial itself,
in terms of how he objected or did or
how he
failed
handled
to
the whole
object?
issue.
So the court clearly asked the defense counsel, do you have an objection? The prosecutor said, oh, the victim's about to testify, we need to clear the courtroom. The court said, do you have an objection? That was the moment for defense counsel to say, we object. Instead, defense counsel responded, we want to make sure that the victim's father is present in the courtroom.
The defendant's father.
Correct. Right. The defendant's father was present in the courtroom, and that was a person with a direct interest. And so the court was applying the statute and made sure that he did meet the criteria to stay in the courtroom, and so he remained. There was somewhat of a shortened proceeding. I think maybe this gets a little bit to it in that this was a second trial, so some of this had been litigated previously. At an earlier hearing before the first trial, there was more extensive discussion, the court discussing its discretion under the statute and how the statute worked, and the court saying, I find it's appropriate in this case. That didn't occur directly before the second trial, but that had taken place earlier with previous defense counsel. So it was a somewhat shortened proceeding, but the court had demonstrated its familiarity with how the statute worked, and it carried that forward into the second trial, and it did comply with the statute in terms of allowing interested parties to stay.
Is there any evidence whatsoever that anybody showed up at the courthouse or the door of the courtroom and wanted to attend the trial?
No, Your Honor. Defendant or petitioner has not produced any evidence that anyone was turned away.
Let me run an impression by you and get your response, if I could, Ms. O'Connell. You seem to be arguing, in essence, we should apply a kind of plain error standard here, that at the very least, there was a forfeiture of any right to keep the courtroom more open than it was, and that there's no showing that would satisfy plain error here. I understand the petitioner to be arguing, in essence, I want to separate the questions of preservation of the issue and the substantive issue, and thereby avoid the distinction from Waller based on the failure to object. Focusing maybe on procedural default, which was not relied upon by the Illinois Appellate Court. I don't know if I'm thinking about that correctly, but I would appreciate any authority you can offer to support, in essence, combining the question about preservation of the issue and the substantive right to a public trial.
We're not arguing that this is a purely procedural basis. So, but I do think that the Supreme Court has been clear that you have to look at the context of the case in which a holding has been issued and view that when you're under 2254D as essentially part of the case. So the failure to object can't be separated out from his argument that this was a violation of Waller. That's a critical factual distinction that we have here. I'm a little perplexed because I did hear petitioner to concede that it would have been fine for the state court to have enforced this as a forfeiture, which is, our argument is that that is exactly what they did, that they relied on counsel's failure to object at the appropriate time and found a waiver based on that. Whether you call it waiver or forfeiture, that was the essential point here. I mean, if that is consistent with Supreme Court case law, as we've argued that it is, then there was no constitutional violation here. So he is trying to separate these points out. They do come together, but I mean, really these are two separate and independent reasons that Waller doesn't apply to the facts of this case. There is the waiver and there is the partial closure. So for both of those reasons, this court should affirm the denial of habeas relief.
Thank you, Ms. O'Connell. Mr. Curran, we'll go back to you. We'll give you 2 minutes for rebuttal.
There are a couple of quick factual issues that need to be clarified here. The trial court did not, in fact, invite defense counsel to make an objection. Defense counsel actually requested a peremptory ruling based on the fact that Mr. Gambiani wanted his father to remain in the courtroom during the victim's testimony. There is evidence that members of the public were excluded who wanted to attend Mr. Gambiani's trial. Those are the two individuals who were attending the trial and were asked to leave by the prosecutor after
The law clerk and the paralegal or somebody.
it was a law clerk and it was
Student or something.
a student, I believe. So in fact, there were members of the public who were excluded from the trial based on, I mean, that's a matter of fact in the record. There is absolutely a difference between forfeiture and waiver. Forfeiture goes to whether or not an argument has been adequately preserved for appeal. Waiver involves whether or not there has been a knowing, voluntary waiver of a fundamental constitutional right. The state appellate court relied on waiver. It did not rely on forfeiture. And because it relied on waiver, the independent adequate state ground doctrine does not apply. And because it relied on waiver, relying on federal law, that's what makes that ruling susceptible to federal habeas review.
Can you point us to federal law, and in particular Supreme Court law, that would say this response is short of a waiver?
Absolutely. I mean, there are several cases that talk about we are to indulge every presumption against.
I'm not talking about, I'm not talking about general discussions of constitutional rights. I'm talking about this right.
The specific
public trial.
A
Yes.
public trial, I don't believe that there is. I believe that, however, there have been there are cases that apply the presumption against waiver in the context of a speedy trial claim, a trial by jury. All of those cases discuss how, in order or before a defendant can make a knowing and voluntary waiver of a fundamental right, they have to know that the right exists. And that's why the circumstances of the waiver
You can
here
waive a
is
speedy trial by just not asking for it, right?
that's correct, Your Honor.
Right? And now I would agree with you, jury trial is an elaborate colloquy that's necessary.
Correct.
What I'm suggesting is that it's not a one-size-fits-all standard for waiver of constitutional rights in criminal prosecutions. And that's why I'm asking you for something more specific, closer to the right to a public trial, that would say this is not a sufficient record for waiver.
I don't believe that there is one.
Thank you.
To be candid.
Thank you, Mr. Curran. Thank you,
you,
Ms.
Your
O'Connell. The case will be taken under advisement. We're now going to move to Appeal 24-2876, AAA Gaming et al. Versus Midwest Electronics Gaming. We've got split argument on behalf of the appellant. Mr. Schatz will begin with you.
Good morning. May it please the court. My name is Brian Schatz on behalf of appellant Midwest Electronics Gaming, LLC. To begin, we'd like to address the subject matter jurisdiction question that was raised by this court in the docketing statement phase, as well as instructed thereafter. In this case, appellees plaintiffs below invoke diversity jurisdiction, and the subject matter, the diversity jurisdiction has two elements. Obviously, the amount in controversy. That element is straightforward in this case. The pleadings raise at issue millions of dollars, which is more than the $75,000 jurisdictional minimum for diversity jurisdiction. Also straightforward is defendant's side of the V for complete diversity of citizenship. On defendant's side of the V is Midwest Electronics Gaming, a single member LLC whose sole member is domiciled in Illinois. On plaintiff's side of the V, the two LLCs have individual members, and both LLCs also have a member who is a trust. Addressing the individual members, all individual members of the LLC are domiciled in South Dakota or Louisiana, meaning that the LLCs will take that citizenship. For the trust, it is a traditional private family trust. And under Supreme Court precedent, specifically Americold, that trust takes on the citizenship of its trustee. And the trustee is domiciled in South Dakota, meaning that plaintiff's side of the V, the two LLCs, are citizens, considered citizens of both South Dakota and Louisiana. Defendant's side of the V, Illinois, meaning that complete diversity remained. I welcome any questions from the court.
None. Thank you, Mr. Schatz. Mr. Murphy, we'll move to you now for the further argument on behalf of the appellant.
Good morning, Your Honors. May it please the court. My name is Jim Murphy. I represent the defendant appellant in this case. Your Honors, this appeal presents a single substantive question, and that is, does a district court have jurisdiction to decide if a party defendant is a prevailing party pursuant to a contractual term after the plaintiffs file a notice of dismissal pursuant to Rule 41A1AI? The answer is clearly yes.
Mr. Murphy, is the mutual release agreement valid and enforceable?
At this point, it's a tricky question, Judge, and I apologize for calling it a tricky question. It's an agreement that the district court had found, that one that purports to control gaming in Illinois. Because of that, and that was based on how these plaintiffs were asserting that contract. Because of that, and because of how they're asserting it, mainly because of the duty of good faith and fair dealing in every contract, it was sent down to the Illinois Gaming Board. And the Gaming Board...
We're aware of the history. My question
Yeah.
is, from your client's perspective, is the MRA valid and enforceable?
And I apologize for sort of getting around it, Judge, but the reason is that the way these plaintiffs are enforcing it was not valid and enforceable. The agreement itself has never been found by the Illinois Gaming Board to be invalid and unenforceable. And I know that's a little bit nuanced, but it's important here because until the Illinois Gaming Board actually goes on record and says, yes, under our rules on gaming, this is valid and enforceable, it can't be enforced the way the plaintiffs were trying to enforce it against my client. So they didn't take the position that, oh no, it's invalid and unenforceable. They just said under the Illinois Gaming Board, and the way it's being enforced here, we can't say that it's valid and enforceable under our rules. Okay. And that was an important part of the case.
You want to follow up?
No, go ahead.
I guess what I'm struggling with is if it's not valid and enforceable, I don't see how any court can enforce the fee provision.
And that's exactly why this matters, Your Honor, because...
I know that's why it matters,
Yeah.
and that's why we're asking for a straight answer as to whether you think it's valid and enforceable. And I haven't heard one yet.
The attorney's fee provision is clearly valid and enforceable.
No, that's not my question. Is the agreement valid and enforceable?
Because it's a provision within the agreement. That's why we're focused on that. So if the agreement is not valid, not enforceable, void, a nullity, there's some kind of problem with the overarching contract, you would think, well, that means it. How can we then go in for a contract that's not valid and enforce a subsection of it as if it were valid?
The MRA is invalid and unenforceable to the extent that it purports to control gaming in Illinois.
Aren't you giving away attorney's fees by that answer?
Yeah, to the
No, because attorney's fees are a separate part of the agreement between the parties, between the plaintiffs and defendant, that says anytime a party tries to enforce it but fails, the other side is entitled to their fees. They tried to enforce it. The way they enforced it was invalid, and we've succeeded. We prevailed.
But it's as if what you're doing, I think this is the reason you're getting the question, or at least it is for me. It's as if we're going through the contract. It has 25 terms to it. I'm just making that up. And we're saying, well, there's no meeting of the mind on 1. There is on 2. 2 is attorney's fees. There's not on 3. There is on 4. That's not the way we usually go about figuring out whether we have a contract. Right?
No,
We don't go term by term, provision by. We ask at the threshold, do we have a valid and enforceable agreement? And then if the answer to that is yes, then you would say, well, that means there's valid and enforceable terms and conditions. And one of those terms and conditions here is an attorney's fee provision.
Understood, Your Honor. And this is a fairly complex case because of the way it interrelates with the gaming rules and the agency administrative rules about gaming. And it's an important point because, and we cite in our opening brief at footnote 16, the Keppel versus cardiac thoracic case. And what that case says is that under Illinois law, this is a quote from the case, the current status of the law on severability of the contract, which is what we're trying to do here, we're severing out that part of the case. The current status of the law is that when some portion of a contract is unenforceable as against public policy, a court may nevertheless enforce the rest of the agreement in favor of a party who did not engage in serious
So does that mean, in
Keep
our
going.
opinion, we have to do severability analysis? We have to apply Illinois law and figure out what survives under a severability analysis?
I don't believe so, Judge, because I believe the prevailing party clause is clear. I believe collateral jurisdiction that the court had allows that. And again, I have to emphasize that nobody has ever found, the Illinois Gaming Board didn't find, the district court didn't find that the MRA is invalid or unenforceable.
Your
The Illinois
quotation
Gaming
from
Board-
Keppel was incomplete.
Pardon me?
Your quotation from Keppel was incomplete.
Mm-hmm.
About if the part of the agreement that is unenforceable is not an essential part of the agreed exchange.
Mm-hmm.
It looks to me like the central part of this agreed exchange is this transfer of control over these hundreds of video gaming machines, right?
Unfortunately, no, it's not that simple, Your Honor, and I
Please.
can explain. Yeah,
Please.
because what happened was it was a sale of contracts. There's something called a use agreement that allows a terminal operator like my client, who's licensed, to own and install and operate video gaming terminals at a licensed location. We purchased several hundred of these use agreements from the plaintiffs. We paid the money, it was about $4 million, and subsequent to that, some of the use agreements were found to be forged. And so we said, okay, we can't use those use agreements. We're not going to install terminals in locations that have forged use agreements. That would be illegal. The plaintiffs sued us because we didn't pay for those. And they sued us, and what they said was, you have to install those. It's part of the contract. You owe us money when you install them, and you have to do it on our behalf, and you have to pay us. And that's when the district court said, wait a minute, that's the plaintiffs who are unlicensed trying to force us to operate games when we shouldn't be operating games. And that's the issue we had here. And that's why it's so important that the Illinois Gaming Board said, yeah, we're not going to call this valid and enforceable.
It strikes me, though, this is a heads you win, tails they lose argument, because you only are asking for the enforcement of the agreement to the extent it's going to advantage you. But that's not what we do as courts. We enforce the agreement if it's valid. And I understand your decision to point to the Illinois Gaming Commission and indicate that they need to give their imprimatur with regard to an agreement. But here we have a case pending in federal court, federal district court, with the judge attempting to make a determination as to whether or not this agreement is enforceable. That's what we have to deal with.
Right, and John, that's a great point. But the distinction here, and I know it's a subtle one, is that we're okay if they enforce the mutual release agreement on the specific language of the text of the MRA. Because the specific text says nothing about us having to install games when with our discretion, we believe it would be illegal to do so. The way they're trying to enforce the mutual release agreement was forcing us to do so when we think it would be illegal. That's what we're complaining about. They can't enforce that against us that way. That would violate the law. That would violate our license. That's the difference. The mutual release agreement on its strict terms would be enforceable going forward. It would be valid going forward. Again, it's the plaintiffs who are trying to remove that discretion from us operating terminals in Illinois. That was against. That's what caused the district court to say, "Hey, you're reading this contract to be one that purports to control gaming in Illinois. If you're doing it that way, you got to go to the Illinois Gaming Board." And the Illinois Gaming Board said, "Hey, we can't give you the relief you want." So it's a subtle distinction, but it's a very important distinction. The text of the MRA is not invalid in that way. It's the way that the plaintiffs are trying to enforce it against us.
Can I switch you back to the procedural issues here? We're familiar with Cooter and Gell and the White opinions dealing with fee awards under other provisions after a Rule 41 dismissal. Can you point us to cases awarding fees under contracts after a voluntary dismissal under Rule 41A?
Yes, Judge. Two cases from this circuit, actually. one of which was 41, one of which was not, but it's contract-based. The first one is the first commodity case we cite in our brief, 766 F. 2nd at 1014. That's where this circuit, this court, affirmed the Northern District of Illinois awarding fees on a contract. In that case, it was after summary judgment had been entered. So after
It's not a
judgment-
Rule 41.
Okay, yep, that's the next one. That's the Berthold case, Berthold versus Adobe. Adobe 242 F. 3rd at 776 2001. That was a Rule 41 dismissal in a contract and a Lanham Act case, and that district court in that case, quote, summarily denied the request for attorney's fees, unquote, just like here. In that case, this court actually reversed that finding, and what the court said was, quote, Berthold litigated and lost on claims arising from its contract with Adobe. The case is remanded with instructions to award legal expenses that arose in connection with the contract, unquote. And that was after a Rule 41 dismissal.
Would you like to reserve the remainder of your time?
Thank you. Yes, thank you.
Thank you, Mr. Murphy. Mr. Lesmeister will now move to you for argument on behalf of the appellee.
Good morning, honorable panel. My name is James Lesmeister. May it please the court. Your honors, I'll go back to the most recent point is made about Berthold. In Berthold, Judge Kness appropriately distinguished that case is because the district court in Berthold considered something outside of the complaint, which was the contract. And it said Adobe contractually did not have to put the fonts of Berthold in the matter. This was something that was then considered a motion for summary judgment, and it was taken out of the 12b6 context. And therefore, that's why there was an award of attorney's fees, is because Adobe substantially won.
Do you know, I want to ask Judge Hamilton's question of you, and that is, do you know of any circuit court in the United States that is held following a Rule 41A voluntary dismissal that there remains jurisdiction to interpret a contract and an attorney's fees and an attorney fee provision?
No. In terms of this, there's proper cases that say that Judge Kness had it right.
Judge Ness.
Oh, I'm sorry.
That's
I was educated in Arkansas, Your Honor.
all right.
So Judge Ness had it right, is when he said is you have to look at what 41A does. And he went through in the May 8th hearing, systematically asking the proper questions.
How would that be different than Section 1988 or Rule 11?
Because those are collateral. Rule 11, let me take the 1988 first, is because 1988 is a provision within a statute that allows the courts to do that. So the cases that they cite where there was an award of attorney's fees, such as the other case that was and it was distinguished by Judge Ness. Just give me 1 minute. Citizens for Better Environment versus Steele. Both of those cases are dealing with federal statutes that allow for attorney's fees. This allows the court to have that collateral jurisdiction.
But how is it different? What makes it collateral, the fact that it's statutory versus contractual?
In this case, what makes the difference is that to interpret this case and interpret this contract, there has to be a judgment on the merits, and there wasn't that. There was no answer, and there was no counterclaim. And it was admitted at the May 8th hearing by Mr. Murphy on behalf of...
But there can be all kinds of cases where there's no judgment, but there's a Rule 11 sanction, there's a 1988 award, and we know, you know, that there's cases that under that, the Steele company, the case you're talking about is the remand, or the post-U.S. Supreme Court Steele company matter in our court, where statutes have to be interpreted, or rules. Rule 11 has to be interpreted, 1988 has to be interpreted, etc. And there's controversy over it, and there's briefs and all that.
In the Steele case...
So why is it that different than having to interpret a contract here?
Because there has to be an adjudication on the merit. Is the common theme you see. Is there judicial imprimatur.
There's no adjudication on the merits in Cooter, though. Cooter is a
Rule 11. And Rule 11 is not an Article 3 jurisdiction, Article 1, allowing the courts to maintain the civility and meritorious function of the court. It's a separate jurisdiction imposed upon the court to allow it to police the court to make sure that everyone is doing what is appropriate and what is meritorious. And go back to the Steele case. The Steele case is the Steele company all the way went up to the United States Supreme Court, and it said that this plaintiff had no standing to bring this case.
So is the line you're trying to suggest that it's collateral and therefore it can be adjudicated post-dismissal if its source is from a statute passed by the U.S. Congress,
A statute,
or a rule,
or judicial imprimatur, meaning that there was a judicial change that will allow for such to happen.
but if the source is a contract or a contract that doesn't do it.
It doesn't do it because you're going to have to, like you said, Your Honor, in terms of this case, you would have to get into the merits of the case. What hasn't been decided, has this case been decided, is the merits of this case. Now, the point that they're trying to make in terms of that, and
I don't think Mr. Murphy needs us to. He's not asking us to decide anything about gaming machines or access, limited act. He's asking us to just deal with the attorney fee provision, not the whole broader dispute.
to deal with the attorney fee position is like this honorable panel brought up, would have to interpret the contract. There's also provision in the contract, as paragraph 5 is, remember, it's a mutual release agreement. So the arguments brought up about there were forgery use agreements and everything else, those were all released in paragraph 5. In essence, what this contract was about is, under the mutual release, you're still required to pay us money.
You're reflecting Judge Ness's instincts here, and you're defending the district court decision. And I understand that would be your position, but the concept of attorney's fees in so many other instances are deemed to be collateral. It's something that would be separate from the merits because we really can't decide that until one party or the other prevails. Why should we separate this type of a attorney's fees provision out and say that it's not collateral while those other ones are collateral?
The distinction here is why this is not collateral, because it requires an adjudication on the merits.
What has to be adjudicated beyond just saying they won?
They won or they lost.
Well, there's where it gets complicated, because if you do reverse the case, which we think is an abuse of discretion standard, we're going to argue is that we're meritorious in that we were proper to bring the case before the district court, and the district court did have jurisdiction because ultimately the Illinois Gaming Board decided it did not have jurisdiction.
And you very well may prevail. The question, though, is shouldn't the district court have an opportunity to make that call?
The district court did make that call and says that it was not a 60B decision to make.
Did I understand you a moment ago to say that you think you're the prevailing side in this case?
In terms of the motion to dismiss that was granted by the court converted it to a 12B6. The reason the court converted to 12B6 is because...
No, after a voluntary dismissal, you're contending you're the prevailing party?
After the voluntary dismissal, if the case goes back down, is what my position would be, is that the whole purpose of their motion to dismiss the case in district court was saying that because it dealt with a underlying video gaming, the Illinois Gaming Board had exclusive jurisdiction. The Illinois Gaming Board says, since it's not dealing with video gaming terminals and you're not licensed under gaming terminals, it's not part of our jurisdiction.
I think you're making it way more complicated than what happened in the federal district court in this building. I thought what Judge Ness had before him was a Rule 41A motion, and he instantly said granted.
Yes.
And he wasn't getting involved in Illinois gaming law or figuring out anything with respect to the right to use or not use gaming equipment. That had nothing to do with what he decided. And then in the next breath, he said, and this is what I think we're reviewing, I don't have jurisdiction to interpret a contract that calls for attorney's fees to a prevailing party. I think that's what happened in the federal district court. And I
Yes.
say that because that's what's in the orders.
Yes, and they're not.
None of it has anything to do with the Gaming Commission.
Well, you'd have to look at what the Gaming Commission did because
No,
their
you don't.
position
That's
is.
not what Judge Ness did.
But the point is that to make the determination whether they're the prevailing party under Clause 8 of that contract is to make a determination of who won or who did win.
What's hard about that here? You dismissed your case, it's over.
It's over, but all that's over is a self-executing as we decided not to go forward. That's all that happened is we decided not to go forward and proceed on the claim that they owe us money under the mutual release agreement.
So they walk away having provided no relief. They're the prevailing party. I got to say, the more I hear about this, I go back to a question that I came upon in preparing for oral argument is, why is this not just an agreement between two groups of robbers that we would just leave unenforceable and leave you to your own devices?
That's right, and it goes back to the question you had of Counselor Murphy in terms of this is there's been no determination whether the MRA was valid or invalid.
Could the fee issue be decided without deciding that question?
No, not at all.
And what's
No.
your response to that question? Because we gave Mr. Murphy a hard time on that. What's your position on the valid enforceability of the MRA?
The valid enforceability of the MRI would require a full trial on the merits.
Is it valid and enforceable in your view?
Yes, it is.
Thank you.
So that's my position, but that's not a position that's ever been reached by the judiciary, by any court, regarding the complicated and long processes.
If it
before-
is valid and enforceable, then, and we think the fees are a collateral matter, then that would suggest we should send this back to Judge Ness for an award of fees
I think then it goes
against
down.
your client.
No, that goes down to the rabbit hole of, okay, if it's valid and enforceable, who is the prevailing party, who was not.
That's
And again,
easy.
It's so, but
That's easy.
I disagree with it, whether
Okay.
it's easy who is the prevailing party or not.
I mean, I think what Judge Hamilton is saying is that we don't have to examine proceedings in front of the Gaming Commission. All we have to do is figure out what happened in the federal Dirksen building. And what happened in the Dirksen building is your client made a choice to voluntarily dismiss under 41A. And Mr. Murphy's client reacts to that by saying, that seems like we won. Case is gone. That's all we're saying.
But as also Mr. Murphy is saying is that the contract was invalid on certain portions, but valid on other portions. And doesn't that require a full trial as to the merits of it? And doesn't that circumvent the purpose of 41A? Because again, the cases that allow for attorney's fees always has that judicial imprimatur. And you don't have that in this case. What is the judicial imprimatur that is void?
Is that true, though? I mean, Section 1988 or Rule 11 fees can be assessed without a merits determination.
But there's still some kind of judicial change in there.
And 5 weeks ago, the Supreme Court issued this Waitzig decision, which says that a district court has the authority to consider a Rule 60B motion following a voluntary dismissal without prejudice. And this is a decision that's telling us that this is something we can consider, even though it was a voluntary dismissal. So we've got something in front of us that we can make a judgment on.
The only way that attorney fees can be adjudicated is to make an ultimate decision who is the ultimate prevailing party. And that requires then a full trial on whether or not the contract is enforceable or not.
Can't you have the same kind of disputes about whether somebody is a prevailing party within the meaning of Section 1988? Section 1988 litigation is not uncommon.
Section 19, well, that's the whole distinction, is that Section 1988 is a statutory provision that allows for that. The collateral matter in that is that there is a statute that provides for the court
But
to
what you're
retain
saying is that,
jurisdiction.
here's the problem. What you're saying is the problem to the panel, or from your perspective, is that figuring out whether Mr. Murphy's client is a prevailing party is going to draw everybody into the contract, and you're going to have to interpret it, and there's going to be a whole bunch of litigation. My point is, isn't there often a whole bunch of litigation about 1988?
Regarding that, but that's
In a civil rights case?
It is, but again, that's a civil rights case, and that's where it's distinguishable, is because it's a civil rights case.
So as a legal matter, what you're saying is that the source of the right to attorney's fees, okay, it's the source of the right that is entirely dispositive as a legal matter. Here, it's a contract. There, it's an act of the U.S. Congress.
It's a contract that's not even declared valid or invalid, and which the plaintiff is Midwest, not the plaintiff, the appellant Midwest is saying is that it's invalid in certain degrees, but it's valid in other parts of it. So that's the difference, and I have 8 seconds left. I didn't have a chance to discuss it, but the denial of a 60B is clearly abuse of discretion, and that's in our Markey versus Federal Reserve Board case, and also Nelson and Wickens.
Thank you very much, Mr. Lesmeister. Mr. Murphy, we're going to go back to you now for rebuttal. We'll give you 3 minutes.
Thank you, Your Honors, and let me say thank you to you for allowing us to divide the argument among counsel for the appellant. First of all, to address the point directly, the Berthold case that Mr. Lesmeister said dealt with, they looked outside the pleadings, but that case was a Rule 41 dismissal case, and it relied on the contract, and this court sent it back for attorney's fees on that contract.
That's a rule dismissal way late, right? I mean, we were on the second or third round of the complaint at that point. There had been new claims added and then dismissed. It was a very, very late proceeding. Right? In
the Berthold case? Yeah, that was a procedural, I'd say, a tricky case. I mean, there were some...
Let me ask you, Mr. Murphy, as you can tell, we're struggling with this, and each of you seems to be making arguments that undermine your client's positions, at least if I understand them correctly. I'm wondering if perhaps we might not decide that the fee issue, I guess much like what Judge Ness decided here, the fee issue under contract is not something we're going to answer in the abstract as to whether it's collateral or merits-based, but to say that at least in this case where the dispute is over the validity and enforceability of the underlying contract, in that situation, the fee issue is not collateral, and therefore we would just say Judge Ness had it correct.
I think that would be inconsistent with clear U.S. Supreme Court precedent, Cooter and Gell in the White case, that we say that they've always taken the position, it's very consistent, that attorney's fees motions are always collateral to the underlying dispute. So I don't think there's any case law.
No, I don't see how you get that general a rule out of them.
If you look at the Cooter and Gell and the White versus New Hampshire cases, Judge, Cooter and Gell, of course, says, quote, "It is well established that a federal court may consider collateral issues after an action is no longer pending. This court has indicated that motions for attorney's fees are independent proceedings, supplemental to the original proceeding, and not a request for a modification of the original decree." And that's at 496 U.S. at 395 to 96. And similarly in White versus New Hampshire, U.S. Supreme Court, 455 U.S. at 451. And that said, the U.S. Supreme Court said, quote, "Regardless of when attorney's fees are requested, the court's decision of entitlement to fees will require an inquiry separate from the decision on the merits, an inquiry that cannot even commence until one party has prevailed."
But this seems, what I'm struggling with is how is this separate from the merits, since it turns on the validity and enforceability of the contract, and maybe I'm just finally catching up with where Judge Ness was on this case.
Yeah, understood, Judge. So it doesn't involve, the attorney's fees provision doesn't involve the enforceability or validity of the contract. And the reason is, Judge, is because like I said, Judge Shaw twice dismissed their pleadings. And the reason he dismissed their pleadings because he said, look, the plaintiffs, you're enforcing this contract, and what they're trying to enforce is what they called the duty of good faith and fair dealing. There's nothing in the text of the contract that the way in which they're trying to enforce it. And so the judge looked at that and said, yeah, the way you're enforcing it, you're requiring Midwest to act as your proxy to install these games. You have to go ask the Illinois Gaming Board first if that's valid and enforceable. The Illinois Gaming Board refused to say that it's valid and enforceable. That doesn't mean that the contract is invalid and unenforceable. What it means is under the IGB rules, under the IGB regimen, the Illinois Gaming Board said, look, we're not going to say that's valid and enforceable the way what plaintiffs are doing with this agreement. And if you look at the text of the agreement, like Mr. Lesmeister admitted, they admit it's invalid, it is valid, and it is enforceable. So we know that it's valid and enforceable, at least for this attorney's fees issue, based on their admission. And nobody has ever said that it's invalid or unenforceable. What we know is that Judge Shaw twice dismissed it on that basis.
I thought you were arguing it's invalid and unenforceable.
No, and if you look closely at the brief, Judge, and this, like I said, this is it's a subtle point, I know. We've always said that the way that the plaintiffs are trying to enforce this agreement against us is that they're trying to make us their proxy to install games and then pay them when we do that. That is illegal under Illinois Gaming Board rules and statutes. But the MRA itself is just paying for use agreements. That is not invalid or unenforceable. So it's a subtle distinction, but it matters here because the way they're enforcing it, Judge Shaw first dismissed it and then dismissed it again, the complaint. And when he dismissed it the second time, he said, and this is in the record, his dismissal was not with prejudice or without prejudice. And the way he described it, he said he was being very cryptic on purpose because he was going to dismiss with prejudice. But he said, you know what, I'm going to let you go to the Illinois Gaming Board to try to make this determination. When the Illinois Gaming Board issued its final board order, final decision, and said, we're not going to say this is valid and enforceable, we can't do it. That then became, what we're saying is effectively with prejudice. And just like, and also the statute, as we read in our briefs, the statute of limitations is also long passed on these claims. And based on the Elmore case that we cite, this is the Seventh Circuit case, we know that because it's been dismissed under 41, this is effectively with prejudice, regardless of anything else. And that makes us the prevailing party also as a matter of law. And so because of that, though, and because of the procedural posture and the way this worked out, it essentially effectively is with prejudice. We know that from precedent. And that gets us to the point Mr. Lesmeister say, it necessarily requires a judgment on the merits. Well, first of all, we disagree. There's no precedent that says that, none whatsoever. But also we believe that we've effectively have that because the precedent makes clear that this case has been effectively dismissed with prejudice.
Thank you, Mr. Murphy. Thank you, Mr. Shates. Thank you as well, Mr. Lesmeister. We've been aggressive in our questioning. We appreciate all your responses, and the case will be taken under advisement. We'll now move to Appeal 24-1403, United States versus Michael Clark. We'll begin, Mr. Brindley, with you.
May it please the court, my name is Bo Brindley and I represent the defendant appellant Michael Clark. When a law enforcement officer has information about an informant's reliability that he knows, subjectively knows, could negatively impact the credibility determination of a magistrate judge and intentionally decides he's not going to provide it and instead provides only evidence that would bolster the informant's reliability, that officer acts with a reckless disregard for the truth. In this case, investigator Moss admitted at the hearing that he knew the credibility of the informant was vital. He demonstrated this admission by admitting that he told the magistrate positive things about the informant's history with law enforcement because it would make it more likely to get the warrant. And then he admitted that he subjectively knew that facts about this informant could negatively impact credibility determinations. And there's lots. There's this person wanted money for doing this. There's this person had a drug problem and was on drugs. This person was under a case, trying to work off a case. He readily admitted, the investigator, that he knew all of those things could hurt a credibility determination. And yet, he decided he would not provide it to the magistrate, admitted that was a decision he made, and then justified it by saying, well, there was no policy that mandated that I do it. Now, that's troubling for a couple of reasons, but one is that there was no policy that mandated that he bolster the informant's credibility either, but he chose to do so. And the idea that a state or police department policy that you don't have to uphold the requirements of Franks could somehow absolve the officers.
Mr. Brindley,
Yes.
this all sounds like a good argument to the district court. Given the factual findings by the district court, what's clearly erroneous about them?
What's clearly erroneous is that that they didn't find under the facts given that it meets the definition of reckless disregard for the truth.
It's an evaluation, it's a subjective evaluation, would you agree?
It is a subjective evaluation, yes, in part. But ultimately, it's a legal determination about what is reckless disregard from the truth that goes back to Sullivan. And the question is, the inferential portion of the Sullivan test, is whether or not there were obvious reasons to doubt.
The district court could have ruled in Mr. Clark's favor.
Obviously, and we think they should have.
On the theory that you've articulated.
Yes.
I'm still struggling with why it had to.
The reason it had to, Your Honor, is because I would submit that in this particular scenario, where the law enforcement officer admittedly subjectively knows he's got bad information that could hurt the likelihood of getting his warrant, chooses to omit it because he thinks he can get away with it based on some policy, and then only bolsters the reliability of the informant, I submit that is reckless disregard for the truth as a matter of law. There is no way that could be...
Can you point us to Frank's cases that apply that make such a finding as a matter of law?
Not explicitly as a matter of law, but we cite in our brief, of course, the Glover case, we cite the Musgraves case, we cite the cases where this court has found that similar instances where there are intentional omissions, and these are intentional omissions. And Your Honor, I think this just creates a very unique
intentional, Mr. Brindley, in the sense that, yes, Moss was aware,
yes,
and he made a choice, but doesn't Frank's turn on intent in that kind of subjective sense that Judge Hamilton is pointing to, intent to deceive the issuing judge?
Well, in a sense, yes, but when it comes, there could be a specific intent to deceive. That's one possibility. Mm-hmm. The other possibility is recklessness. And as a matter of law, that's a thing to be considered here. This court remanded for consideration of his honesty and cautiousness, carefulness with respect to the facts. This investigator was plainly and admittedly not careful with respect to these facts. His testimony was surprising to me in the district court in that he readily admitted, yes, I knew this stuff and I knew it was bad. I knew it could impact the magistrate's determination, and that's important. This law enforcement officer knows he's going before the magistrate and he's looking for the magistrate to make a decision. He wants him to decide his way. He knows information that will make it less likely and admits he subjectively knew that would make it less likely and chose not to put that in because there was no policy that said he has to.
What do you do about the passage in the district court opinion where the district court said, even if you altogether exclude all this, there's plenty?
Well, Your Honor, I think this court originally, when this appeal was first before the court, dealt with that in looking at what else there was, and there was nothing else beyond what was in the record before that was added at this hearing about the corroboration. The corroboration that this court found to be woefully meager, to use the language that this court used in the original remand of the case, remains meager. There was no way to find probable cause based on the other items without the informant. If that is the position of the district court, that position is plainly erroneous based on this court's already evaluation of the other corroborating evidence. And what is unique about this situation and troubling is that the officer went to court and testified in a way that suggested as long as we have a department policy that says we don't have to do this, then I can know that this would hurt the likelihood of getting the warrant and keep it out, and I'll be okay. And what that suggests is the department policy could absolve the officer of his constitutional duties. And that cannot be the case. The magistrate has no way to make an informed decision. The officer knew that he was omitting items that the magistrate would need to make an informed decision. Even if Moss himself says, well, I believe the informant, Moss himself also knew that the magistrate was going to make the decision. He knew that the magistrate had to make the determination on the magistrate's own. And he knew that material that he admitted would make that less likely is something he chose not to put in. And we submit that that is reckless disregard for the truth, and any finding to the contrary is certainly clear error.
Would you like to reserve the remainder of your time?
I would, Your Honor. Thank you.
Thank you, Mr. Brindley. We'll now move to the argument on behalf of the appellee, Mr. Reinhardt.
Good morning, David Reinhardt representing the United States in this appeal. Mr. Brindley makes a lot of good arguments regarding getting a Franks hearing, but we're beyond that. You know, he got his Franks hearing and raises some reasons that, in fact, he ignores the reasons that he has to prove that it's recklessly or intentionally deceptive. And we had a full Franks hearing on that particular issue where the court was able to ask questions of the affiant in the case. The defense had the ability, the defense cross-examined investigator Moss on that. And the court weighed all that evidence and determined that, in fact, he had presented credible reasons as to why he had omitted this information. He was not intentionally or recklessly deceptive, and that's the standard. That's what stage we're at now in this proceeding.
Mr. Reinhardt, can I ask you, you all make the point in your brief that law of the case really precludes all this. The reason I have some difficulty with that is I'm aware of what we did in the prior opinion. I sure didn't think we were foreclosing Mr. Brindley from after a Franks hearing. Franks hearing happened, just like you talked about, from now coming up in our court and arguing that either there was a legal error in the Franks hearing or there was a error with respect to the finding of facts. I didn't think we were precluding a second appeal. In other words, challenging the outcome of the Franks hearing. Did you read us to be doing that?
That's how we read it. I mean, we read it that the court was expressly stating that, look, if the judgment is reinstated, which
after you made that argument, I reread that dispositive paragraph that I wrote, and for the first time understood how you might reach that conclusion. I don't think we could foreclose a second
I'm not
appeal
sure
properly, could we?
Well, I think you could. I think if it is a legal ruling or a legal decision.
Well, I think I don't want to put words
in
in his mouth, but Mr. Brindley and his colleague there may say, look, if you're pre-terminating an appeal, if right now you're saying you can't appeal in 2025, the outcome of a hearing that hasn't happened now, I would think what he would argue is that that's a due process violation.
Well, it's a flexible standard.
Like a summary reversal from the Supreme Court. Okay, kind of due process problem.
I don't think we need to get too wrapped up in it. Go ahead.
Yeah, you've got a deferential standard of review on the merits. So.
And I'll just close it. Look, at the law of the case is a flexible. It's not a straitjacket. I mean, they just said that it's something that is discretionary. But based on the express words, that's why we argue.
Yeah, go ahead. Don't worry about
that. But yes, I think getting to the next point, even if a law of the case doctrine does not bar the appeal, Clark can't show that the district court's findings were clearly erroneous in this particular case. I mean, these were detailed, well-reasoned findings made by the magistrate, and ultimately found that investigator Moss was credible. And in 2015 in Wisconsin, and it has to be put back into context, back in that time frame. It was not the practice to include the credibility information. Not saying it was the best practice, but
Do you know,
he wasn't trained.
Do you know, Mr. Renner, whether the practice has changed?
Yes.
As Judge Scudder originally suggested?
Yes. On the record, I think Investigator Moss
I think there's
stated during
in the
hearing
transcript of the hearing, I think there's a reference to the fact that
there is a reference
Yeah.
that has training, and now there's training regarding the case law and putting the adverse credibility information in the affidavits.
Yeah, I mean, I don't understand. You don't disagree, do you? At least at a general legal level, with Mr. Brindley's point that needs to be in there. I mean,
Yes.
that stuff needs to be in there.
It's a better practice.
Somebody's
as
using
you
drugs, or they're getting paid, or they've got 6 felonies, or whatever.
Well, it's a better practice to have the judge have all the information in the case, the good and the bad. And I think we've evolved in that regard as the case law has evolved in that area. But going back to Investigator Moss, he wasn't trained to include it. Supervisors didn't require it. This just wasn't department policy in the case. I mean, he would submit these affidavits to assistant district attorneys. They would review them, and they weren't requiring it. And then when they brought those affidavits to the state court judges, they didn't have any questions about it. And I think at the time, as the magistrate put in his report and recommendation, that it was a practice that was disfavored just because they thought it would disclose the CI based on a prior record. Because of that, there was no intent to deceive the issuing judge in this case, and that's what the district court found.
I understood the point to be that, in essence, most of the judges on the ground in that part of the state understand that somebody who's providing confidential information about drug dealing probably are not model citizens.
Correct. I think, yeah, judges who are practicing understand that these CIs don't come with clean hands almost most of the time. If there aren't any further questions, the government will rest on its brief and ask this court to affirm the district court.
Thank you very much, Mr. Reinhardt. Mr. Brindley, we'll go to you now for rebuttal argument.
Thank you, Your Honor. Ultimately, Your Honor, I think the problem here is, and as I hear them describe it, they are saying that if you have a policy, a statewide policy or a district attorney policy, that you don't have to follow Franks. Franks was the law. Then an officer can say, well, I'll give them the good stuff and not the bad stuff, and that's going to absolve me of any problems. The magistrate has to be able to ask questions to determine reliability. And he can't ask questions about things that he doesn't know. Now, I think this would be a different situation if Investigator Moss had answered my questions by saying, these issues with the informant, I didn't think those could impact a credibility decision. But he admitted that they could, and that he knew that they could. And saying that, well, I didn't think I had to, but I put in the positive stuff anyway, that is by definition an admission that he's giving a misleading picture to the magistrate judge. And he knew he was giving a misleading picture to the magistrate judge. All he does really is anchor the act of giving a subjectively known misleading picture to the magistrate judge of the informant is to tether it to, well, there was a policy that said we didn't have to, or I didn't know. And that doesn't change the fact of what he did know. And that's where I ask Your Honors to focus. What he did know. And what he did know was that there was positive things that would help him get a warrant that he included. There was negative things that he knew in his own mind subjectively could hurt. And he decided he wasn't going to put them in. So he absolutely, as a matter of logical necessity, knew that he was giving a misleading picture to the magistrate judge, and that is reckless disregard for the truth. And any finding otherwise is clear error, because to find otherwise would be to sanction officers knowing that they're giving a misleading picture to a magistrate because they want to get a warrant, and getting away with it because they say, well, there was a policy, so it was fine. The fact that they changed it after the fact is evidence they should have had that, gotten it right in the first place. But nothing changes the fundamental bedrock fact for us that he knew he was giving a misleading picture to the magistrate and admitted as much at the hearing, and that's reckless disregard for the truth. We think that requires suppression and that the case should be remanded. Thank you.
Thank you, Mr. Brindley. Thank you, Mr. Reinhardt. The case will be taken under advisement. We'll now move to Appeal 24-2239, United States versus Zachary Barnes. And we'll begin with oral argument on behalf of the appellant. Ms. Cruz, we'll start with you.
May I proceed?
You may.
May it please the court, my name is Alessandra Cruz and I represent appellant Zachary Barnes as supervised by Professor Robert Palmer of Notre Dame Law School. Your Honors, the central issue in this case is whether Barnes was a supervisor of co-defendant Marquise Neal for purposes of the sentencing guidelines. It was this determination that led the lower court to find that he was ineligible for safety valve relief, and it is this issue that we focus on here today. If we prevail on the role enhancement issue, we further argue that Barnes did not possess a firearm in connection with his offense, and therefore he should be eligible for safety valve relief.
Can I pause you at the outset real quick?
Absolutely.
I don't mean to interrupt you. I just want to clarify what it is that is before us. I totally get the 3B 1.1 organizer, leader, supervisor, 2-level enhancement. I got that part. Are you separately and independently appealing the 2D 1.1 firearm enhancement? Or are you appealing it simply for, or are you injecting that into this appeal for purposes of making a point about safety valve relief?
To make the point about safety valve relief and why it wasn't harmless error for the court to have ruled incorrectly on the first issue,
Was there a separate and freestanding challenge in the district court to the 2D 1.1 firearm enhancement?
Not to the firearm enhancement, Your Honor. Yes to the safety valve question, but only as to the enhancement for the role.
Okay, sorry to interrupt you.
No, absolutely. Thank you, Your Honor. So to turn back to the role enhancement issue, the lower court erred in finding that Barnes was a supervisor for 2 reasons. First, it relied on inconsistent and unreliable testimony when making that determination. And second, even if Neal's testimony was appropriately considered, Barnes' described conduct does not rise to the level sufficient to make him a supervisor.
Ms. Cruz, one reason that the district court found Neal credible was because it would be highly unlikely that Neal would know where to go and what to do without Barnes' directions, given that Barnes was the only one communicating with the CI. Why shouldn't we affirm the district court's credibility finding on that basis? There'd be no other reason to know where to go or what to do but for that relationship.
Well, first, Your Honor, Neal gave his phone number to the informant on 2, if not 3 occasions. So the phone was actually never taken to confirm. It was only based on his testimony that it was seen that he did not discuss things with the informant directly. However, I believe that even if Barnes was the main person who was handling coordination as far as the logistics of where to meet with the informant, there were still many other activities that Neal was involved in. He was still present at meetings. He was still saying that he could provide fentanyl. He was still culpable, and therefore, under this common sense inquiry of 3B 1.1, Barnes should not be seen as more culpable than Neal, Your Honor. So to turn back to that point of control, here it's clear that Barnes did not exercise control over Neal. To start, Neal had a tremendous amount of involvement in the enterprise. He wasn't just an errand boy who answered to Barnes' demands. As I mentioned before, he was involved in closed-door meetings. For example, on the controlled buy on October 18th, the informant met with both Barnes and Neal in Barnes' vehicle. Neal provided his phone number at that time, and Barnes introduced him. The informant stated during debriefing that Neal said he could provide marijuana, guns, and fentanyl, and keep in mind he said all of this while Barnes was present. This court has held that involvement in closed-door meetings like this can signal someone has higher leadership. Further, during testimony, Neal stated that he could name the suppliers at times, even stating that he was with them at moments. He noted that he went to high school with these individuals. This sort of understanding of the enterprise as a whole and its extension shows that he had knowledge that was beyond just delivery. Second, Barnes did not appear to be using Neal as a cover in this situation, which is a posture that's common in relationships of control. He was present at almost all of the transactions, and he even did transactions where Neal was not present at all. Neal was asked about this directly in the testimony That's on page 21 and 22. If Neil would go alone most of the time, and he said, quote, "We would work together most of the time." Third, and I think most...
As to the sales that they work together on, don't you have to keep circling back to Judge Brennan's question that when they were working together, Mr. Neal was taking direction from Mr. Barnes as to go do this sale with this guy, take this gun with you this time.
Your Honor, I would disagree with that characterization. I think that characterization comes from Neil directly in his testimony, and that's kind of how that framework came to be. But I actually don't think that Barnes saw Neil in that way, and I think that's seen by Barnes' endorsement of Neil's own leadership here. For example, Barnes was the one who allowed Neil to give his phone number. When the informant asked, "Can I talk to Neil directly?" Barnes did not stop her from doing that. During the October 17th buy, the informant reached out to Barnes beforehand and said, "I would like to discuss fentanyl. Should I do that with you or Barnes?" And at that point, Barnes said, "Neil will be there. You can talk to him about it." And so I think if you see this relationship where Barnes is controlling, say, "Just do that," he would have taken control in that situation. I think that's especially clear here because originally this informant had a relationship with someone else, and Barnes was able to kind of build a relationship with him by giving the phone number, by taking leadership there, and so he understood the ramifications of having Neil have more contact. Further, by having more contact with the informant, Neil was making on-the-spot decisions here. You know, he was having to answer questions that put him in a space of control as well. To point to some other examples of his leadership...
If it was equal, why was Neil getting paid in marijuana?
Your Honor, so Neil mentioned during his testimony that he smoked marijuana often. In fact, he said that he smoked every single day and would often, even when they weren't engaging in this business, would buy from Barnes. And so I think there's, a potential here that Neil simply had different goals in this enterprise. He was looking to get drugs when Barnes may have been looking to get money. Your Honors, additionally, these same facts that I'm pointing to, if we don't want to focus on control here, I think can be seen in other factors that the sentencing guidelines point to. For example, Neil was involved in meetings, as I mentioned, which points to a higher degree of participation on his point. It also shows to more about his nature of participation. Further, sharing his number, once again, put him in this position where he had to be able to answer questions on the fly. But Your Honors, to get to a larger picture here, 3B1.1 is about culpability, and here Barnes was not more culpable than Neil. Rather, the evidence shows, when looked at as a whole, that Neil had a tremendous amount of autonomy. He had understanding of the main players here. He took initiative with the criminal enterprise and with the informant. At one time when Barnes was already in jail, Neil actually went to go get a firearm and to continue this action without him present. And so I think under these circumstances, the supervisor enhancement is inappropriate. So for those reasons, we ask this court to remand for resentencing. And unless there are further questions, I'd like to reserve the rest of my time for rebuttal.
Thank you, Ms. Cruz. That will be granted.
Thank you.
Mr. Whalen will move to you on behalf of the appellee.
May it please the court. Good morning, Your Honors. Nathaniel Whalen here on behalf of the United States of America. Mr. Neal provided testimony that filled in the gaps of what the evidence showed that was neither contrary to laws of nature nor physically impossible, and so the district court did not clearly err in crediting his testimony. Once you accept his facts, this case falls right within this court's case law about what an organizer, leader, manager is, and Mr. Barnes appropriately was given the organizer, leader enhancement and therefore denied safety valve relief. Judge Scudder, I guess let me quickly address the question you're asking. There was no challenge to the 2D1.1 enhancement. I don't think, though, that that's dispositive of the safety valve issue under this court's case law in Bingham. There's a difference between the possession and furtherance of and the possession in connection with enhancement. And as I understand the defendant's argument to be that, yes, Mr. Barnes might have had a gun, but it wasn't in connection with the drug trafficking offense. And so we think that is wrong under the facts as we argued in our brief.
So I know this isn't your position, so suppose we agree with Ms. Cruz on the 3B1.1 issue.
Yeah.
And so that's off the table for purposes of sentencing valve. Is it your view that this court should then take up the gun issue?
We argue at the end of our brief that this court could take up the gun issue because we think the facts support the enhancement, not the enhancement, the disqualification of safety valve. The district court admittedly didn't make that finding, Chief Judge Brady skipped over that question because she found that Mr. Barnes was an organizer leader.
Yeah.
Is this the case to do it then?
Your Honor,
She hasn't made a finding?
yeah, no, I understand the court's point. The court might not be inclined to find that particular factual issue. We think the facts in the law are there to find it if this court wants to. We understand also that the court usually doesn't make factual findings. Regardless of whether this court, even if this court found in favor of the defendant on that issue, though, there's still the fact that he hasn't proffered, so he can't get safety valve relief by this court under any circumstances. So if this court disagrees with us and finds there's clear error, it should, he's still not eligible for safety valve under any circumstances. But we don't think there was a clear error in the court's believing of Mr. Neal. As Judge Brennan noted, there's the fact that Mr. Barnes objectively is coordinating all these transactions with the CS and the text messages. He's setting the date, he's setting the time, he's setting the quantity, he's setting the prices. He and he alone is interacting with a confidential source. The videos and the officer's observations show that it's in fact Neal who's physically handing over the drugs. And, I don't think it's right to say that Mr. Barnes didn't use Neal as a cover. Yes, Barnes might have been hanging around the periphery of some of these transactions, but he's still not directly involved in most of these transactions. There is the one in the car where he's there with Mr. Neal and the CS comes in, and so the both of them are there. But in most of them, Barnes is off in a sporting goods store or he's at his house. And in each instance, Neal either leaves Barnes' house for the drug transaction or he goes back to Barnes' house for the drug transaction. So Barnes is still involved. He's just having Neal actually do the delivery for him. Under this court's case law, that is a manager, organizer, leader, pretty consistently. Judge Brennan, I apologize. He is paying Neal in marijuana. Barnes recruited Neal to this particular conspiracy. That's what Neal testified to. That's what Chief Judge Brady found. That finding isn't clearly erroneous either. So if you take the facts that we have Neal's testimony that's consistent with all the other evidence in this case, that Chief Judge Brady found was credible, that she found supported the organizer-leader enhancement, we think this court should affirm the sentence.
Is there anything in the record that speaks to Barnes wanting Neal to be the one in direct jeopardy and him being in indirect jeopardy?
I don't think... There's no explicit statement by Neal that, Barnes told me that he's using me as the fall guy. Okay. I think that's a reasonable inference based on the fact that it's Barnes coordinating these deals and he's sending Neal on his behalf. He's the one. There's the one deal, I guess, where Barnes arranges it and Neal delivers the drugs. The confidential informant says, "I thought you were going to come. I wanted to talk to you about a pistol." And as I recall the text messages, Barnes says, "No, I sent my guy instead." So there is the text, supporting that inference. There's no explicit statement by Barnes or Neal, though.
Thank you.
Unless this court has any further questions, we would ask that you affirm the sentence.
Thank you, Mr. Whalen.
Thank you.
Ms. Cruz, we'll go back to you now for rebuttal argument.
May I proceed?
Yes.
So just to start with the firearm issue, to clarify there, I don't believe that this court should determine the safety valve issue solely on the firearm basis here, considering that it wasn't looked at in the first instance in the lower court. This court has recently held in United States v. Sams that safety valve eligibility is incredibly fact determinate, and so I believe that kind of general principle should apply here. Your Honors, turning to the role enhancement issue, the government describes the conduct that took place here in straightforward terms. Barnes did all of the organizing while Neal simply showed up and handled the drugs and the money in the last instance. This is not the reality of what their relationship was like. The record, when looked at as a whole, shows Neal had much more involvement. The government says that he, pointing to Barnes, and he alone was discussing with the informant, but that simply wasn't true. During the February 17th controlled by, Neal directly was speaking to the informant about what Barnes could not get. He said that Barnes was unable to get a firearm in that instance, but that he would talk to his friend and would make that happen. During that same controlled by, the informant stated that she was having legal troubles and was just discussing more generally with Neal, showing that they had a relationship themselves. But also, I think Neal's response there was telling. He said, "I'll take care of you." So this simple framework of Barnes having all of the orchestration, having all of the relationship, doesn't do justice to Neal's role and his involvement. As I mentioned, he also was involved in meetings. He had that initiative, and he knew some of the main players here. Your Honors, the 3B1.1 analysis is about culpability at its heart, and here Barnes is not more culpable than Neal. For the foregoing reasons, we ask this court to remand this case for resentencing, instructing the lower court to remove the role enhancement and make Barnes eligible for safety valve relief.
Thank you, Ms. Cruz. You have the thanks of the court, as well as thanks to Mr. Palmer for the involvement in the case and the representation on behalf of Mr. Barnes. Thank you as well, Mr. Whalen, for your representation, and the case will be taken under revisement. We're going to move now to our final appeal of the morning. This is Appeal 24-2486, SuperValue Incorporated versus UFCW Union and Employers Midwest Pension Fund. We're going to begin with oral argument on behalf of the appellant, and Mr. Miller will recognize you first.
Good morning, and may it please the court, Evan Miller for Appellant SuperValue, Inc. In this appeal, the parties all agree that SuperValue complied with the ERISA Section 4204 safe harbor when it sold stores to Schnucks. The parties also agree that when SuperValue later withdrew from the fund in connection with operations unrelated to the sold stores, the fund properly excluded the contribution history for the sold stores when it performed the initial step of calculating liability under ERISA Section 4211. The only issue before this court is whether the contribution history relating to the sold stores should also have been excluded when the fund performed the second step to determine withdrawal liability under ERISA Section 4219.
You're asking us to incorporate 4204 into 4219. Is there a specific part of the 4219 that you're saying that the safe harbor provision goes into, the unit calculation or the rate calculation?
Well, 4219 talks about base units and a calculation that needs to be undertaken that involves a 10-year look back to determine the high water mark. And what we are saying is that the court should engage in the traditional and accepted canon of statutory construction.
We're looking for a textual anchor for what you're asking for.
The textual anchor within the language of 4219 itself comes from focusing on the word employer. The particular operative language in 4219 at issue in this case involves an examination of base units, quote, for which the employer had an obligation to contribute. At the time of the withdrawal, by operation of law, the employer no longer had an obligation to contribute for the, and in connection with the assets it sold in the 42.
But it did during the 10-year look-back period.
I'm sorry?
But it did have that obligation during the 10-year look-back period.
Yes,
correct?
But this court's jurisprudence, particularly the Messina case, Central States versus Messina, provides that in connection with withdrawal liability analysis and the determination of an employer and what constitutes an employer, you measure that at the time of the withdrawal. So at the time of the withdrawal, by operation of law, SuperValue no longer had an obligation to contribute in connection with the sold stores. And so that contribution history gets hived off, and then in connection with the remaining contribution history, which relates to the stores that were terminated, that's the contribution history that you engage the 10-year look back and high watermark.
Mr. Miller, I had understood both sides. You can speak for yourself and your counterparts can answer. I had understood both sides start from several positions of agreement here, but one of which, when it narrows down to the legal issue before us, is that in the operative provision of 4219, and it's a mouthful, the Roman 1, when you drill down into 4219C, that everyone agrees that there is ambiguity on the precise question before us. Am I mistaken? And now, you've got arguments about how to resolve that and why you think it should resolve in SuperValue's favor, and so does the fund on their part. But am I right, at least in understanding that you both agree that Roman 1 in 4219, drilled down, does not answer the question expressly?
For SuperValue's part, we absolutely think the provision is ambiguous.
I didn't think the fund thought it was ambiguous. I thought they
I
thought it was silent.
I don't think
You're arguing silence is ambiguity, right?
Yes. Well, we're arguing
That's very
essentially
explicit in your opinion, in your brief.
Yes, we're arguing ambiguity, I think, in two forms, Judge Hamilton. First, yes, there is silence in the operative language of 4219. And indeed, the district court acknowledged that the operative language in 4219 does not speak one way or the other as to how the contribution history for the sold stores should be addressed. But in addition, we think, consistent again with the jurisprudence of this circuit, that if you step back a little bit from the isolated language in 4219 and look at the related provisions, notably 4204 and 4201 and 4211, those provisions, their purpose, their language, makes it even more clear that 19 is ambiguous. Sorry.
I understand that you think it would be a good idea if the statute had been written to accommodate your client's concerns here. Obviously, neither the arbitrator nor the district judge found language that would let them do that. One quick aside, you referred a moment ago to our jurisprudence in the Messina case.
Yes.
Was that in your briefs?
It is. I think it's in the...
What's it called?
It's in the opening brief. It's Central States Pension Fund versus Messina. And on rebuttal, I'll get you the page.
706 F3rd
Yes.
874. Cited on page
got
29.
it.
Yes, 29, that's right.
Okay,
Page
thank you.
29 and 30.
Okay.
Thank you.
I guess I understand you to be relying very, very heavily on the Borden case and the argument that the fund is being inconsistent between step one and step two, and that's your best argument, in my view. Borden was obviously concerned about potential double recoveries by retirement funds. That seems to me at least, to have been the whole basis driving the result to do some pretty aggressive statutory interpretation there. My question is, you seem to be arguing, though, that as we consider the possibility of potential windfalls or double recoveries, we should also put on blinders and not pay attention to the 20-year cap on annual payments for withdrawal liability, which had a dramatic effect in reducing your client's withdrawal liability here, correct?
Well, that is correct. We don't think that the 20-year cap rule has any implication and play in how the 4219 language should be interpreted.
If the Borden analysis is based on preventing windfalls, potential double recoveries, why not look a little more broadly, as the arbitrator did here, to say, you guys already knocked your potential liability down by more than $70 million here. Why should we knock it down another 10?
I think that Congress, in particular in connection with the 20-year cap, seriously considered and came up with rules in the statute to address how pension funds will receive monies that are not paid by a withdrawing employer as a consequence of the 20-year cap. And let me elaborate. Back to section 4211, this time 4211, I think B for Cap A and Cap B. They provide, taken together, that in calculating a withdrawing employer's share of unfunded vested benefits, the unfunded vested benefits will include that withdrawing employer's share of amounts that are not paid by prior withdrawing employers as a consequence of the 20-year cap. So in other words, Judge Hamilton, the statute itself provides rules for how monies that are not part of, in this case, super values withdrawal liability as a consequence of the 20-year cap, will be paid off in the future.
By other employers who are withdrawing.
Exactly. And as a consequence of Congress's serious consideration of that issue and coming up with rules to address that issue, we would urge that this panel not disrupt those judgments and try to read into 4219 some attempt to achieve a rough justice balance.
Well, the district court and the arbitrators weren't the ones trying to read things into the statute. You guys are, right? And what I'm trying to address is understanding where Borden is coming from and how it may apply to these circumstances where your client is already, as I say, there was a quite clear paragraph from the arbitrator, page A26, page 11 of his decision, where he goes through all the ways in which your withdrawal liability has been cut down already. And where I'm struggling with is a compelling reason to imply language that's not in the statute to knock it down another 10 and shift another $10 million in potential liabilities to other employers in the plans.
Well, I've provided one answer, and that addresses the 20-year cap issue. Let me provide another, which very much animated the Fourth Circuit's reasoning in Borden. The Fourth Circuit focused significantly on the interplay between 4204 and 4211 and how they work together. And in doing so, the Fourth Circuit recognized that a primary purpose in 4204 and an important legislative purpose in the withdrawal liability scheme writ large was not merely to have withdrawing employers pay their fair share, but to create rules to promote new employers coming in so that they can be longtime contributors to the pension fund and help overall funding.
Right.
And,
it's an incredibly complicated statute, right?
It is.
Balancing an awful lot of competing policy considerations. That complexity suggests, at least to me, that we shouldn't be tinkering by trying to add language of the kind that you all think should have been in the step 2 calculation.
But as I say, I think that this court can interpret that language focusing on the text itself, and in particular this notion of who the employer is at the time of the withdrawal, in a way that easily allows for our interpretation, and that furthermore, our interpretation is consistent with and would lead to a harmonious whole that would allow the objective of 4204 and the objective of 4201 of ERISA to be given full force and to be consistent with how all parties agree 4211 should be interpreted.
Mr. Miller, can I ask you a
Yes.
question about interpreting the plain meaning of 42, the Roman 1, okay, which is the first part of the multiplication that has to occur there to figure out the annual payment. Why not, if the 4204 transaction needs to be considered in the determination of employer withdrawal liability, and in particular the computation of the payment, the annual payment, mindful of the 20-year cap, why isn't the best interpretation, if super value is insisting that we cannot forget the 4204 transaction? That's basically what you're saying. Why not include the 5 sold stores contribution histories for years 2 through 10, but not year 1 in the 10-year look-back computation? And why am I saying that? Because that would seem to map the kind of factual economic reality of the period in time in which super value held the 5 stores that were the subject of the 4204 transaction. Do you see what I mean?
Yes,
In other words, the sale of those stores occurred in September of 2018. The transaction that gives rise to the withdrawal liability is not that transaction. It's the transaction that happens in November of 2018. Okay. If the November 2018 event is what's giving rise to the withdrawal liability, and you have to calculate the payment of that or the repayment plan of that, say, okay, account for the 4204 transaction. It most recently occurred in year 1, looking back 10. Do you see what I mean?
Yeah,
but it's not there in years 2 through 9 because, in fact, super value was making contributions for the sold stores in years 2, year 3, year 4, etc. Why isn't that the best textual?
I would say that under your proposed construction, Judge, 4204 does become completely thwarted because you end up with the same result in this case, which is the following: that the fund is receiving 2 streams of payments. Schnucks is continuing to provide contributions in connection with the sold assets, just as super value used to. And in addition, the fund is getting a second stream of payments. The fund says it's $1.1 million. We say it's $500,000. And that $600,000 difference is completely attributable to the contribution history of the assets that were picked up.
This is helpful because I've had a hard time understanding economically the double recovery argument, okay, or the double recovery worry or concern, or whatever, however everybody wants to phrase it, okay, because we know what, or I think we know what. It's just a matter of how it gets apportioned and over what schedule it gets paid. But we know the top dollar, don't we? Amount. We know the upper limit of the unvested benefit liability here.
Yes, but
nobody's going to be paying more than that.
But the true withdrawal liability amount is the amount that is paid. It's the amortizable
over those 20 years.
It's the amortizable amount over those 20 years. That's the true financial cost of the withdrawal liability and the true withdrawal liability amount.
So
And
is,
what
is the point,
go
is the
ahead.
reason you guys are choosing the words double recovery, quote unquote, is because you're saying, I guess this is what you're thinking, what they're thinking. If you overpay on a 4219 calculation, so you overpay over the 20 years, that means the fund is receiving more that it's entitled to under 4219. It's receiving more than it's entitled to as a matter of withdrawal liability. And because it's receiving more, let's go ahead and call that double recovery.
It's a windfall, because again, Schnucks, as the successor, is paying the contributions and needs to pay the contributions at substantially the same level that SuperValue did prior to the transaction.
But that's by
So
operation of 4204. That's
That's by operation of 4204. And in addition to that, what the fund is obtaining is an additional stream of contributions that are really comprised of two parts. One part relates to the contribution history for the stores that were closed. And we have no objection to paying for that. But the second part, which happens to be the majority, that relates exclusively to the contribution history for the sold stores. And so, as a consequence, the fund, God bless it, it's getting double payments.
No, but it's
windfall.
step one, though. It's step one.
Yes.
The accounting for the 4204 transactions took you from your prospective liability of 96 million, right, down to 42.6, correct?
I believe that's correct.
So, and the substitute for that $50 million is the Schnucks contributions going forward, right?
It is the Schnucks contributions going forward.
Right.
But if SuperValue had yes, go ahead.
I'm still having trouble understanding how that's a windfall or double payment then to when we're talking about the difference between 500,000 and 1.1 million in the annual 20-year payments.
It's a double payment if you focus on things from the fund's perspective, because what
I'll
the
be interested
fund,
to hear what they have to say
but
about that.
what the fund was receiving before the sale and before the withdrawal was one level of a contribution stream. It's now getting two. And not only is it getting two, but the bulk of the second contribution stream is entirely based on the contribution history of the assets that were sold. And if I could go back just for a moment to the text in 4204 and 4201, I think it will buttress my argument that this is a double recovery that's in conflict, irreconcilable conflict with those two statutory sections. 4204 says, if you engage in an asset sale that meets the conditions, there will be no withdrawal considered. 4201A says, in the event of a withdrawal, the withdrawing employer has to pay withdrawal liability, and then subsection B sets forth the various steps in that equation. What has happened here is that a portion of the withdrawal liability payments are attributable to assets that were deemed immune from a withdrawal as a consequence of 4204, yet SuperValue is still paying a liability on those assets as part of its withdrawal liability. It's not supposed to pay any withdrawal liability under 4201 if there's been no withdrawal under 4204. But it's doing so, and it's putting the fund in a better position than it would have been in the absence of the 4204 transaction in the first place. And that's what I think was driving the concern of the Fourth Circuit in Borden, and that concern has full application to the determination of the scope of the language in 4219.
Thank you, Mr. Miller. We
Yes.
will give you some rebuttal time.
Thank you. I appreciate it.
Thank you.
Judge.
We'll now move Mr. Murphy to you. We've transformed into the DC Circuit here, so we're going to be a little flexible in terms of the amount of time.
Sounds good.
All right, Mr. Murphy, on behalf of the appellee.
Good morning, Your Honors. I want to dive in right where Mr. Miller left off on the concern in Borden. So if you look at the discussion in Borden about the double recovery, the double recovery that Borden was concerned about was in the instance that the withdrawn employer and the purchaser, the two parties to the sale, are both paying withdrawal liability, that is the amount determined under 4211, on the same contribution stream, on the same contributions from the sold assets. That's undisputedly not at issue here. This case involves a assessment under 4211.
Nobody's challenging like the application of Borden to get to the 42.6 million that, you know, the math dispute kind of starts from, right? So you've accepted that. The Pension Benefit Guarantee Corporation seems to agree with that. So
correct, Your Honor. And I guess the point that I'm making is there's been a lot of discussion about double recovery this morning. That was the concern of Borden. That may be a double recovery. We could leave that argument for another day. The double recovery that Mr. Miller is advancing is not supported by the calculations that actually occurred here.
Yeah, I'm with you to this extent. Double recovery is a mischosen term for a 4219 overpayment. Okay, what they're basically saying is you'd say just get rid of the term double recovery. What he's saying is super value is overpaying, right? But there's no way it's a double recovery. I don't even know how mathematically you'd ever even get to the point of a double recovery.
I mean, we would have to collect $96 million from super value as well as whatever that delta is between the two from Schnucks. So I agree with you, Your Honor. But as to adopting your term, the overpayment, there is no overpayment. We followed the plain language of 4219. We considered super values contributions that actually made to the fund in establishing that annual payment. And I think it's important to recognize in this discussion the purpose of 4219. 4219 does not establish liability. I understand that Mr. Miller is using kind of the more commonsensical liability and amount you owe another party. That common terms in ERISA don't often maintain their ordinary meaning. The liability that super value owes to the fund, its share of unfunded vested benefits, that's all under 4211. The purpose of 4219, as recognized by the Supreme Court in the Schlitz case, is to approximate historical contribution levels by the withdrawn employer. We accomplished that. That purpose is served by the calculation we engaged in this case. Super value is paying an annual payment that approximates amounts that it paid historically under the mathematical formula defined by Congress.
Can I push you a little bit on this?
Sure.
Okay. So here's the move that throws me off a little bit the portion of the 4219 calculation that throws me off. Okay. Is when we read 4219, it seems to me that the fund, very understandably, is saying, okay, we got the 10-year look-back period in Roman 1. You with me?
I'm with you.
Okay. So we got to go back 10 years to compute the contribution base units. And the question on the table is, should we be mindful of those 5 stores that were sold in the 4204 transaction? And if the answer to that is yes, how should the 10-year look back? And what the fund does, as I understand it, is it says, oh, okay, yeah, we do think it's relevant. It's not irrelevant, the 4204, and it's relevant to this extent. The 5 stores are going to be out in the first 5 years of the look-back period, years 1 through 5, okay, and in for contribution unit in years 6 through 10. And then I think to myself, okay, why?
So
okay, because of 4204B.
Correct.
Okay, that's the part that you got to help me with.
So the best way to understand this, in my view, is to look at it over the sequence of events. So at the point of the asset sale, two things happen. There's a safe harbor from a withdrawal. No withdrawal occurs as a result of the sale. And then also an assignment occurs under 4204B, as Your Honor was just mentioning. Once that assignment occurs, it has happened. That is no longer SuperValue's contribution history. It is now Schnook's contribution history. And we have to read 4204B that way, because to read it otherwise would be to go down the path that Borden was concerned about. We would be holding both SuperValue and Schnook's primarily liable for that contribution.
Yeah, that's why nobody's fighting Borden.
Right. So 4204 accomplishes the transfer of contribution history, and then at the point of the subsequent closure in November of 2018, we look back 10 years from the year before the withdrawal to add another layer of complexity to this math. It's two different 10-year periods, but the 10 years leading to the year of the withdrawal, and we say, what are SuperValue's contributions over that period? Let's find the 3 consecutive year highest average contribution. We multiply that by the highest rate, and you got your annual payment.
Right.
So that's how I reconcile, and that's how I think that's the only way to harmonize these 3 statutes and adhere to the plain language used in those statutes. To do what SuperValue is asking for would require you to rewrite 4204B, to add an additional 5-year assignment. And I think it's worth noting that some of the case examples they've provided, including the Centra case from this court, deal with other safe harbors that do accomplish that transfer of contribution history.
See, I think the plain language of Roman 1 if you get really literal about it, leads to the conclusion that you should include the contribution history as it was as a matter of fact in that 10-year look-back period. So the 5 stores are in for years 1 through 5, and they're in for years 6 through 10.
And I think that. Oh, go ahead.
Okay, and so you got to advocate, but I thought I read your brief to be saying, no. If we get that literal with it, in for 1 through 5 and in for 6 through 10 on the sold stores, you're not in any way accounting for the 4204 transaction that occurred. As a matter of fact, and therefore, in the fund's view, the lack of clarity, if you will, the silence, ambiguity, the gap, it doesn't matter to me what word you pick, is resolved by resorting to 4204B for direction. That's what it seems like the fund's doing.
So 2 points in response. First, I think it's notable that SuperValue isn't arguing that had we considered that 5-year period, the annual payment would be different. So to me, it's kind of neither here nor there. But to directly answer your question about I believe that is a reasonable reading of that statute. I think that because of how 4204 talks about the transfer and primary liability by the purchaser, and the fact that with respect to all ERISA statutes, we obviously have to interpret them harmoniously, it makes sense to the fund to exclude that 5-year contribution history under the 4204 assignment.
A follow-up question on that, specifically to the PBGC letter. Mm-hmm. So the district court asks why the fund here excluded the sold stores units for the most recent 5 years. And I believe it was you below
Correct.
said, you point to the PBGC letter, which the fund interpreted as requiring these 5-year reduction. If we end up agreeing with your interpretation of the entire statutory scheme, do we have to account for the PBGC letter, or do we hold that the fund does not have to exclude for any of the 5 years?
I don't believe you have to account for the PBGC letter, because the PBGC letter was talking about the calculation of withdrawal liability under 4211. In other words, the total amount. So the PBGC says when you're accounting for their share of unfunded vested benefits, they get credit for the fact that that contribution history under 4204, the 5 years, including the sale and the preceding 4, are assigned to the purchaser. 4211 is a completely different calculation. Under 4219, we could have considered that 5-year period. And I, to be honest, Your Honor, I'm not exactly sure what point in the transcript you're referring to, but I would imagine that my reflexive response is that, Well, if the PBGC has said that 4204 transfer occurs and subsequent events take that into account, that we should do that in 4219 as well. I think that that's a reasonable way to read the statutes together. I don't think that's the only way to read the statutes. I think you certainly could literally read 4219. And again, I think that's consistent with the purpose of 4219, to establish a withdrawal liability payment, the annual payment, at a level consistent with what the employer has done historically. Considering those 5 years would accomplish that purpose.
Do you think you had to give SuperValue the benefit of the 4204 sale in step one?
Yes.
And I want to make sure I understand the statutory basis for that.
What I would say, first of all, Your Honor, is I know SuperValue talks about withdrawal liability being calculated in 2 steps. We dispute that's the case. We think these are 2 different calculations. One is their share of unfunded vested benefits under 4211. But to your point,
and then the second is what's the annual payment?
That's what they treat as 2 steps as part of the same equation. I don't think that accounts for the purposes of each statute. One is to determine their share. The other is to determine how they pay it. In the Schlitz language, the charge and how you go about paying the charge. But the textual basis for excluding in the 4211 calculation the 5-year contribution history from sold assets is 4204B. And that is that's also what's subject to the PBGC letter that I was talking about with Judge Brennan.
This court does not have a lot of opinions with flowcharts. Sentra is very complicated. What do you consider to be the holding of Sentra, or is it more than one holding?
So I guess I would consider, and I'm going to contextualize it to this case because it is an extremely complicated fact pattern in that case. But essentially what the court was grappling with is the effect of various corporate reorganization events. There was a drop-down sale, and then there was also a stock sale. And I would not be able to tell you which entities were involved in which, but they were 2 different transactions, neither of which are at issue here, right? This is not a corporate restructuring where SuperValue moved its stores to a subsidiary. It's not a stock sale where a purchaser ordinarily, as the court recognized in Sentra, takes on the contribution history of the predecessor entity. So I say all of that to say the holding in Sentra was whether those events qualified for the safe harbor from withdrawal liability in 4218, what I refer to as the reorganization safe harbor. Okay. That safe harbor does include a complete transfer of contribution history to the purchaser, which is the opposite. Well, I shouldn't say the opposite, which is not what occurs under 4204. So my point in raising that is Congress knew if they wanted under 4204 to protect the seller from any possible future liability related to the contributions made on behalf of sold assets, they could have adopted the approach they did in 4218. They didn't. They limited it to the 5-year period, leaving 5 years with the seller.
Thank you.
And your response to Judge Hamilton is that the textual hook, the better textual hook for the position on 4211 liability in connection with the 4204 sale, the partial or complete withdrawal liability, okay, is 4204B is the answer to that question. 4204B because it tells you where the contribution history goes with respect to the purchased assets.
Correct. And what I would add to that is it's specific about what contribution history goes, and because goes
for
is
the
assigned
5 years
for those 5 years, and because it's specifically limited to those 5 years, the remainder stays with the seller. Mm-hmm. There would need to be some other provision of ERISA, and Mr. Miller has not cited in the briefing, he's not going to argue it today. There is no provision of ERISA that assigns that pre-5-year contribution history to anyone else. It stays with SuperValue. And I guess I would echo Judge Hamilton's comment earlier that when faced with such a complex statute, the fund adheres rigidly to the language, and we would ask the court to do the same. The only assignment that occurred in this case is that of the 5-year contribution history of the sold assets. No other assignment occurred. So at the point the fund is determining the annual payment under 4219, it was entirely appropriate for it to consider the pre-5-year period as SuperValue's contributions, because after all, SuperValue paid those contributions to the fund. If there aren't any other questions, I would rest on their briefing.
Very good. Thank you, Mr. Murphy. Why don't you come forward, Mr. Miller, and we'll put 5 minutes of rebuttal on and whatever you would like to take.
Thank you, Judge. I'd like to first go back to the question that you asked of appellee Judge Hamilton about 4211 and whether the fund felt compelled to interpret 4211 to give a complete exclusion of the contribution history. And the fund said yes. The operative language in 4211 is almost exactly the same as the operative language before the court in 4219. It's essentially the same statutory construction exercise. And indeed, although the Borden court was focused on the interplay between 4204 and 4211, the Borden court was interpreting that language. And it is our view that if this court were to affirm, it would be analytically and in terms of its statutory interpretation result, creating a conflict with Borden.
What exact language, just so we have it clear here, what exact language in 4211?
Yeah, let me take a look at it. So the crucial language in 4211, and it's in a very lengthy subpart, 4211 C2, cap C, 2 Romanet, says that the 4211 calculation in pertinent part is one in which the pension fund is going to examine amounts, quote, required to be contributed by the employer.
Sorry.
42.
Sorry,
Yes.
I'm trying to follow you closely.
Yes.
Exactly where, and I'm going to call it 1381, 4211, but exactly each step of the designation.
The language that I just quoted to you is in 4211, small c, cap 2, cap C, 2 Romanet.
Sorry, C2,
Cap C, 2
Romanet 1?
Romanet 2. Romanet 2. It should say amounts required to be contributed by the employer.
Sorry, I see capital I's and lowercase i's, and I want to make sure we're looking at the same language. I've got you at capital C.
Yep. So at capital, I'm sorry, capital C, 2 Romanet, and 2 Romanet begins with a fraction.
Okay.
And then look at Roman numeral 1 after that.
Okay, thank you.
The numerator of which is the, quote, total amount required to be contributed under the plan by the employer. 4219 says in pertinent part that the pension fund is going to examine contribution base units, quote, for which the employer had an obligation to contribute.
And you, where are you in 4219?
I'm in 4219, I believe, small c, 1, Cap C, Romanet 1, Roman numeral 1.
For which the employer had an obligation, okay.
Bingo.
Okay.
And the general
And-
legal concept that you're relying on is a presumption of consistent usage or a canon of imparted materia, because these are different statutes.
They're different provisions, but they're very closely related, which is why we believe the in pari materia doctrine of statutory interpretation applies. Because now I'll take you back to 4201 small b. 4201 small b sets forth the various steps in determining the withdrawal liability amount. The first step is to determine the withdrawing employer's share of the unfunded vested benefits. Judge Brennan, that's the 4211 calculation. And then once you have that number, there are additional steps and adjustments, and a crucial additional step is to determine the amortization amount and determine whether it's going to be capped by 20 years or not. That's the calculation in 4219. So the 4211 calculation and the 4219 calculation are both part of an overall calculation of withdrawal liability. And the operative language that we just went through in these very technical subparts is essentially the same. And when the fund concedes that for 4211 purposes it has to exclude the contribution history, it's our position that as a matter of statutory construction, and in order to be consistent with these very closely related provisions that are part of the same overarching exercise, you've got to have the same construction of 4219 and eliminate the entirety of the contribution history. I want to make one more point. It relates, Judge Scudder, to what you asked of fund counsel and what I'll call the 4204B issue, because it's an important issue here. You asked whether fund counsel would concede that if you include both years 1 through 5 and years 6 through 10, that would frustrate 4204. And you said yes, and that is analytically correct. So you suggested the solution to the issue is 4204B and kind of splitting the years 1 through 5 and 6.
So what I was doing with that is I very much think that the best reading, if you're going to be very, very literal, of 4219, the provision we're talking about, is to include the sold stores in years 1 through 5 and to include them in years 6 through 10. Okay? But, and that would have the legal policy benefit of maximizing funding, avoiding shortfalls, furthering the 1980 amendments, and the downward spiral that Congress was worried about, all the stuff everybody knows here. Okay? But if you adopt that construction, the challenge that you run into is you have to square it with the way 4211 is being interpreted. A little bit of the point that you were making, 4211 is being interpreted for purposes of determining the unfunded vested liability number at the top level and what Schnucks is responsible for by virtue of the 4204 transaction. It's, in other words, if you read 4219 in isolation, you might think what I did about interpreting it but we tend not to read statutes in isolation. You want to read them as a harmonious whole. So that's what I think is the difficulty about the case, is that 4219's plain language points you in a direction, but the direction doesn't make a whole lot of sense out of the statute.
We agree with that, and we agree with your point that if you take this very literalistic reading,
that's not what the fund did. It's not what anybody's done.
It's not what the fund did, and it gives no weight to 4204. But here's the point I want to make, and it's my crucial last point. 4204B, which talks about years 1 through 5 and 6 through 10, that text only addresses the following issue. What portion of the contribution history relating to the sold stores the buyer gets if the buyer is to later withdraw? That text says nothing about the years 1 through 5 as it relates to the seller's withdrawal liability if the seller first engages in a 4204 sale and thereafter, in connection with its residual operations, closes them. So that's why, Judge Scudder, we believe primarily that as a textual matter, you can't use that language in 4204B to solve, essentially, Judge Scudder, the issue that you rightfully raised about the problems of a literalistic interpretation of 4219. And instead, if you will, you've got to go the distance to give the interplay between 4204 and 4219 the proper effect by excluding the entire contribution history. Thank you.
Thank you very much. These
Yes.
are excellent briefs, excellent arguments. Our thanks to Mr. Miller and Ms. Rodriguez, as well as to Mr. Murphy, Mr. Hanson, Mr. Carmel. Thank you for an outstanding presentation.
Thank you very much.
The case will be taken under advisement, and the court will close its hearings for today.